Your lordships, kindly may make a submission, my lord.
24.
And 25.
At the request of learned counsel for the respondent, poses matter on 4th February. Yes.
My lord, serial
That's serial
number
number 45.
serial number 33, my lords. Settlement talks are going on between the
We
parties.
will
your
look
lords.
at, look at the docket, what has happened, then we'll see whether, how many times the time is sought. Yes,
Serial number 45.
yes.
This writ petition is filed seeking for a direction to implement the order passed by the trial court. For a direction to the police to implement the order of the trial court. Subsequently, suit itself is decreed. Probably this may not survive. May I request your lordship to kindly have it next week? I'll probably withdraw the writ petition itself.
Serial number, sir.
45.
In that case, why next week? Why not today?
Soon, I thought that can be recorded and closed.
Can be recorded.
Please,
yeah.
please.
They submitted that the main suit itself is OS number so and so is disposed of.
Decreed.
Nothing
Is decreed in my favor.
is decreed in view of the same. Nothing survives for consideration in this writ petition, accordingly dismissed. Yes,
May I just make a mention, my lord?
yes.
My lord, item number 34 and 35. My lord, I've
Yes.
been briefed in these matters, my lord. If today I have a little personal inconvenience, if my lords could kindly accommodate me sometime, my lord, any day in the next week.
You're appearing for whom?
For the petitioner, my lord, in both the cases for the petitioner.
Who
Both the
appears to the respondent?
Respondent, J.A. Jacob.
Is it informed to them?
Yes, my lord, we shall inform. We shall inform. And my lord, generally they are not appearing much in this matter.
This is matter on Tuesday. No
With
further
my lord's
adjournments will
kindly.
be granted.
I'm so grateful, my lord. I'm so grateful.
My lords, one
Lordships,
submission.
With my
lordships,
lord's
kindly,
kindly,
my lord.
my lord.
Serial number
Serial number-
42, my lords, I am for the petitioner.
Hmm.
I seek for short accommodation, my lords. My lords, inconvenience, my lords, the arguments counsel is not there in town, my lords. That is the reason, my lords, I pray for the short accommodation. Maybe listed next week.
So
itself.
first of all, the court is not at all entertaining. Now the whole, the process with Mr. Arun Govindaraj, it started. Now it's continuing. We don't, all the matters, at least every matter is repeating at least 10 times before this court.
My lords, it may be listed next week itself.
When did it came before the court earlier? That's what I wanted to see. List this matter also on Wednesday. No further time will be granted. Yes,
Grateful.
May I make
My
a
lord's
submission, my
kindly,
lord?
serial number 40.
Serial number
my lord.
9, my lord. I'm
Yes, my
serial
lord.
number 9.
yes.
If your lordships may kindly grant me a week's time, my lord, I'll go on with the matter on the next date of
One
hearing.
minute, yes.
Serial number 9, my lord, I oppose for an adjournment. Yesterday, it was heard by the official liquidator, my lord. Under Rule 178, my lord, there is no part to, we are not opposing to condone the delay, my lord. But subject to Rule 178, that observation may
Yes,
kindly.
I need to
How can it
look
be
into it,
done
my
at
lord.
the
I've got
time of
some.
mentioning? How can
Lord-
all these be done at the time of mentioning? Please wait.
My lord,
Mine
my
will
lord,
be-
I have got some
One minute,
medical
one
emergency, my
minute.
lord.
Yes,
I've
Mr.
got some
Counsel.
medical emergency today. I need some time at serial number 9, my lord. Lordship, may kindly have it
Sir,
on.
wait, sir, wait.
Yes,
Serial number 53, my lord.
50?
53.
Oh,
Today I have got some personal inconvenience. My wife is not well. So could it be given 1 week's time?
this is matter. Inform the other side.
My lord, serial number 40, my lord.
Jayant Kumar.
Why the court is not audible? 53, at the request of learned counsel for the petitioner.
With
List
my
this
lord's
matter.
kindly, serial number 40, my lord.
Sir, now that 53 is dictating, sir. You wait for.
This matter on 4th of March.
May I request your lordship to extend the interim order?
Look at it. If it is extended on the last occasion, yes. Yes, Mr. Counsel.
My lord,
Lord, serial number
I have
9.
undergone an operation, my lord, and kindly there, week after next, my lord, serial number 40, I appear for the petitioner, my lord.
40
Why you are seeking adjournment?
I have
Yes,
undergone an
sir.
operation, my lord,
for respondent.
week after next, your lordship, my kindly.
This is matter on 12th of March.
Serial number 9. may
My lord,
also-
may I,
next
10th,
week,
my lord.
Serial
10th
number
of March.
52, my lord.
Obli.
Serial number 52, my lord. May I have it in next week, my lord.
Why?
I am for the petition. I am little inconvenienced. I am not attending the court today, my lord. May I have it any day next week, my lord. I am for the
Wednesday,
petitioner.
at the request of the counsel, the petitioner. Entire list, I think we better adjourn it instead of calling
Yeah,
each
sorry.
case.
Your lordship's
Yes.
kind
Only
indulgence,
for
my lord.
due to inconvenience.
Yes,
There is
Serial
an
number
interim
9, my
order,
lord.
my lord, which must be extended, my lord.
yes.
Serial number 9 may kindly be taken up next week, my lord. I've got some personal inconvenience.
That is yesterday's matter.
Yesterday, yes, my lord, you listed yesterday. I've got some medical emergency. I may not be able to stay on, my lord.
Yes, my lord, the
Sorry for the
OL has no
inconvenience.
objection. OL has no objections to condone the delay in the matter, your lordship.
Sir,
Only
I've got some personal inconvenience, sir. I'm
under
saying
Rule
that medical
178, my lord.
emergency.
We'll have it on Tuesday.
Very well, my lord.
Yes, list is marked on Tuesday at the request of learned counsel for the petitioner.
My lord, serial number 52 interim order is there, my lord. It has to be extended. I request to extend
If
the
it is
interim.
extended on the last occasion, it will be done.
Please,
Yes,
ma'am.
call the list.
List number 1, part matter, serial number 1.
Appear for the petitioner. But this
It's not a
petition.
third matter.
On submission. It was one learned counsel appearing for respond for 1 to 4 minutes.
1, 2,
Or
Four.
Mr. Ramesh Manoj. He suffered Manoj head injury Manoj and he is in coma. He is not able to Manoj give NOC also Manoj. I am filing Manoj along with medical certificate. I am filing wakalat on behalf of respondent for 1 to 4.
But today it is scheduled for auction, my lords. That's the urgency.
Because, in fact, Manoj, the Vernet trial judge has called for a report for today, Manoj. Auction is not scheduled for today. It is only called for a.
By the learned counsel that learned counsel the petitioner submits the auction is scheduled today. Learned counsel representing the counsel for the respondent R1 to R4 submits that the counsel has suffered a head injury. And further, it is submitted that the auction is not scheduled today as per his instructions. When do you want?
No, it's anytime, Tuesday or Wednesday.
Let's just matter on 31st. 31st.
Lords,
31st?
Please.
even shorter date notes if auction.
31st is next week. 1 week.
My name, Manoj, in the wakalat could be.
Print the name of
PH Virupaksha.
so and so.
My lords, in the stage of preliminary hearing itself, my lord, for
Keep
consent.
it there, the same.
Because today it was taken for top of the list because auction was scheduled, my lords. Men-
No, preliminary hearing, same group it will come. Yes.
Part matter, serial number 2.
My only apprehension is in B group, it may not reach, that's the one.
It will reach. Every day I am completing the list.
Please.
Yes.
May I
Only
seek-
yesterday because the matters or company
understand.
matters are there. Yes.
Appear for the
May I seek password, my lord? I'll come. My lord, one of my colleagues is holding the file, my lord. He'll come, my lord. Kindly password, my lord. I'll go on with the matter today, actually.
2:30.
Yes, Passover is at 2:30.
Please.
Yes.
Serial number 3.
But it's Monday at least, 2:30 other matters. Okay.
Yes, this
Tuesday,
matter,
my lord,
Wednesday.
Sorry.
29.
Please.
Tuesday
No,
not
please,
possible,
please,
Wednesday.
Please.
Serial number 3. BV Vidyulata for petitioner. K. Venkatesh for R2.
Yes.
Lords, this matter, the suit was for mandatory injunction and possession and for permanent injunction, Lords. In respect of a small portion of property, which the petitioner alleges that the defendant had encroached upon and had put up a compound wall.
What is the suit for?
For possession, mandatory injunction to demolish the compound and for permanent injunction against the defendant. It is the allegation, my lords, of the petitioner that her husband had purchased her property by virtue of a sale deed.
For the plaintiff.
I am the plaintiff.
What is IA?
My lords, for appointment of commissioner. My lords, what happened was after the evidence, my lords,
Came to be dismissed.
that came to be
First
dismissed.
you will look at the impugned order, then you make.
Yes, my lords. Annexure A, my lords, page 9. Could I
Come to the reasons.
reasons at page 11, my lords? The learned counsel for the applicant/plaintiff has vehemently argued that at the time of cross-examination of DW1 by her, with regard to appointment of commissioner to measurement of the suit schedule property to the witness, and he admitted that he has no objection for appointment of court commissioner. And even otherwise, his case is that the defendants have encroached 32 feet into 9 feet of B schedule property on the southern side of her property. The documents produced in the suit by the parties do not indicate the extent of encroachment made by the defendants in order to ascertain the exact encroachment. The learned counsel for the respondent/defendant has vehemently argued that this case is posted for arguments, hence the interim application is not maintainable, and the IA filed to drag the proceedings by one or the other reasons, and hence liable to be rejected. The contents of so and so, my lords. Para 8. On perusal of entire pleadings material documents which are clearly demonstrate that the plaintiff has filed the suit against the defendant to issue mandatory injunction directing the defendants to remove the compound wall put by them on encroached portion of A schedule property, which is described as B schedule property, and put the plaintiff into possession, and to grant permanent injunction restraining the defendants, their agents, servants, etc., from interfering with the plaintiff's peaceful possession and enjoyment of A schedule property and other reliefs. Admittedly, this case was posted for arguments after conducting a full-fledged trial. When the case was posted for arguments, the learned counsel for the plaintiff has filed this application seeking appointment of court commissioner to measure the extent of suit schedule property of the plaintiff and defendant property. As during the cross-examination of DW1, he has submitted no objection to appoint court commissioner. On perusal of cross-examination of DW1, wherein he has stated that he has no impediment to survey the property through court commissioner. However, if the defendant has stated that he has no impediment to appoint the court commissioner, it is not presumed that it should be appointed to the court commissioner. It is the duty of the court to ascertain whether this is proper stage to appoint the court commissioner, or appointment of court commissioner is necessary in order to adjudicate the matter finally and effectively. It is pertinent to note that this IA is filed with the applicant after completion of the evidence of both the parties and in the stage of argument to measure the entire suit schedule property of the plaintiff and defendants. Since he has filed the suit for mandatory injunction and permanent injunction, it is the duty of the plaintiff to prove the alleged encroachment by the defendant on the basis of oral and documentary evidence, and not with the help of commissioner. It amounts to collection of evidence. For this application is filed in the belated stage when the case was posted for argument on 11/4/2020. So this is the thing. My lords, admittedly, nobody is disputing anybody's title. The plaintiff, my lord, says her husband purchased her property, which is A schedule property, by virtue of a registered sale deed, which is not disputed by the defendant. The defendant says he has purchased the property under 3 sale deeds. That is also not disputed. Now, the question before the trial court, my lords, was whether each person is in possession of the extent of land or site that is mentioned in their registered document. No amount of oral evidence, my lords, can show as to the encroachment.
2009.
My
When
lord
was
says.
application filed?
The application is filed on in the argument stage, my lords. That is not in this.
2018.
Yes, my lords, because
You have not realized that till such time.
I mean, it's not
Commissioner for-
necessary. If my lords, I'll make this submission, my lords. If the defendant had admitted that, my lords, the question is put to the defendant. I have the cross-examination. If your lordships, if I could pass on, I usually don't do this, but in the cross-examination, my lords,
Yes.
if your lordships could see page in page 5.
Yeah.
It is false to suggest that defendants have encroached the property of the plaintiff. It is false to suggest that myself and my henchmen are threatened with the plaintiff. I do not know the plaintiff have lodged the police complaint. I do not know police have approached the plaintiff to civil court as a matter is civil in nature. It is false to suggest that in spite of advice of police, myself and defendants have encroached the plaintiff's property. I have deposed on behalf of the defendant. The defendants have not executed any power of attorney to me. I know the documents produced by me in the case. They go on, my lords. Here, the second para, defendants have purchased 3 properties to the extent of so-and-so. It is true to suggest that 20 feet of width of the said 3 properties are acquired for formation of the. This is the problem, my lords. Both the plaintiff and the defendant lost an
Please
I'm sorry.
complete this.
All 3 properties are situated within a compound. The boundary description of the said compound is east by road, west by property, private property, north by private property, south by road. I do not know where the plaintiff's property is situated. I do not know the plaintiff's property is situated towards northern side of my compound wall. It is false to suggest that. I have put the compound wall, including the plaintiff's property. This is the entire crux of the matter, my lords. I cannot, until and unless I cross-examine the defendant, I cannot, my lords. It is true to suggest that in my property, garage is situated. It is false to suggest that I have not constructed the shed adjacent to the garage, but it was constructed within the garage. I am in possession of the said garage and shed. It is false to suggest that the shed is belonging to the plaintiff. Witness voluntarily stated that it is my land. I am in possession of the same. I have no impediment to survey the property through court commissioner. I do not know the plaintiff has sold half the property, so on. So this is all the matter, my lords. My submission to your lordships is just this. Unless and otherwise, my lords, I cross-examine the defendant and he or she denies, my lords, encroachment. If I was able to get it from the mouth of the witness, my lords, that they have encroached, there was no need for such court commissioner. In similar circumstances, my lords, this honorable court, the same judgment which is relied upon by the trial court to say that this is not the correct stage for appointment of commissioner, my lords, has looked into this, my lords. May I read, my lords?
Yes.
Even here, after completion of the evidence, the plaintiff has filed an application, my lords, which your lordships gets at first para. The fourth para, my lords, would be relevant for us. Learned counsel for the petitioner submits that the application filed by the plaintiff belatedly for appointment of commissioner, that too after completion of evidence, when the matter stands posted for argument, is not maintainable. The exact same thing was argued in that case also. My lords, para 6, the suit is one for possession and injunction, alleging encroachment against defendant number 1. The parties have led their evidence and the matter is at the stage of argument. The application filed by the plaintiff for appointment of commissioner is on the ground that the defendants have put fence and encroached into suit property, and such encroachment could be ascertained only by surveying suit property.
Yes.
Well, when there is an alleging encroachment, any amount of oral or documentary evidence would not assist the court to come to a proper conclusion. Lords, my submission is the petition, lords, is of the year 2018. Till today, the suit has not gone on because the matter is pending. Lords, a number of times I have moved this honorable court. My suit. I have moved this honorable court a number of times. The respondent did not come, and if your lordships could see the audit sheet, every time it was instead, my lords, at that point of
Wanted
time.
it to continue from 2009 to 25.
No, my lords, I do not want to. 18, it was only for appointment of court commissioner, my lords. My lords, I have the evidence to show that I'm in possession, my lords, by virtue of a sale deed that was purchased by my husband. They have 3 sale deeds, my lords. It's only the court commissioner who can ascertain whether they are in that possession of that much of property, and I am in.
No, in a way, you're seeking injunction. According to you, you're in possession of the property.
Yes, ma'am.
And somebody, a part of it is encroached by the
By
defendant.
the defendant.
No, by appointing a court commissioner, you want him to collect the evidence.
It's not collecting of evidence, my lords. The evidence is already before the honorable judge. The evidence that it's the dispute which the defendant is saying, I have not encroached upon the property of the, if my lords, my title to the property or my title deed was under dispute, yes, my lords, I would be collecting evidence through the thing. Both of us are.
In a suit for injunction.
It is for mandatory injunction also, my lords. Kindly see, my lords.
Oh, the prayers are kept here and there. The suit is for permanent injunction.
Yes. Injunction and
At a
yes,
consequential
mandatory.
injunction.
Yes, my lords.
So in a suit for injunction, advocate commissioner should be appointed and to say who is in possession of
My
which
lords,
property.
now it's my oral evidence against the oral evidence of the defendant. There is nothing beyond that, and nothing beyond would.
That can't
Kindly,
be done.
may I pursue your lordships just to see para 7 of the judgment, and I'll stop.
Yes.
Para 7 minutes. My lords,
Yes.
in this is discretionary power. I cannot go beyond this, my lords. Para 7.
yes.
Therefore, I am of the view that the trial court has rightly allowed the application and appointed the commissioner for local investigation with regard to the encroachment. The contention of the defendant that the application filed belatedly at the stage of argument is liable to be rejected, as appointment of commissioner would depend on the facts and circumstances of each case, and there need not be a straitjacket time frame to file application for appointment. This is B.S. Nazir Hussain cases distinguished,
Yes.
stating that at para 6, my lords, this honorable court says, The suit is one for possession and injunction, alleging encroachment against defendant number one. The parties have led their evidence and the matter is at the stage of arguments. The application filed by the plaintiff number one for appointment of commissioner is on the ground that the defendant have put up fence and encroached into suit property, and such encroachment could be ascertained only by surveying suit scheduled property. When there is an allegation of encroachment, any amount of oral or documentary evidence would not assist the court to arrive at a proper conclusion. When there is a report of a surveyor with regard to the allegation of encroachment, it would be a great assistance to the court to come to conclusion. So this is just my submission, my lords, but this is the discretionary thing. My lords, instead of pulling the matter, my lords, if a court commissioner was appointed, since there is no dispute as to title between the parties, the only thing he had to identify was whether they are in proper this. That's my submission.
Please come. Agreed with orders passed in I number 13 in OS number 968 of 2009, dated 19 September 2018. The plaintiff is before this court. The plaintiff had filed a suit to grant permanent injunction, restraining the defendants, their agents, servants, interfering the plaintiff's peaceful position, enjoyment of the suit is scheduled property. To issue a mandatory injunction directing the defendants to remove the compound wall put up by them on the encroached portion of the A scheduled property, which is described as B scheduled property, and the plaintiff to put the plaintiff into possession. The suit is of the year 2009. After the entire evidence is vetted and then the matter is posted for arguments, at that stage, an application came to the I number 13 came to be filed, seeking appointment of the commissioner to measure the entire plaintiff's suit scheduled property and the defendant property. That came to be discussed by the court by way of the order impugned, wherein the court observes that the present IA is filed with the applicant after completion of the evidence of both the parties and at the stage of arguments to measure the entire suit scheduled property of the plaintiff and defendants. The court observes that the suit is one for a permanent injunction and a mandatory injunction. It is a duty of the plaintiff to prove the encroachment by the defendants on the basis of oral and documentary evidence and not with the help of the commissioner. It amounts to collection of evidence. Further, the application is filed at the latest stage and the case was posted for arguments on 14/4/2018. Again, for the defendant arguments on 24/4/2018. At that time, the plaintiff has come up with the present IA court relying on the judgment of this court in B.S. Nazir Hussain Khan versus Ashwath Narayan Rao and others, reported in 2004 to Karnataka Law General 191, has come to the conclusion that such an application cannot be entertained at this stage and accordingly dismissed the IA. Aggrieved thereby, the plaintiff is before this court. Then counsel appearing for the plaintiff submits that when there is no dispute with regard to the title and in the cross-examination, when the defendant has stated that he has no objection if the surveyor is, the court commissioner is appointed to survey the land. And that's the only issue between the parties. There is no difficulty in appointing the advocate commissioner. The finding of the court that the application is at the belated stage and it amounts to collection of evidence is contrary to law. It is submitted that there cannot be any straitjacket formula either to allow an application for the appointment of commissioner or to dismiss the same. In that regard, she had relied on a order passed by a coordinate bench of this court in B. Girish versus J. Darshan, arising out of red petition number 10852 of 2016, wherein an order dismissing the appointment of commissioner was questioned before this court. And there also, the case of the plaintiff is that the defendants have encroached the property of the plaintiff the court has set aside that order passed by the court and observed that when there is an allegation of encroachment, any amount of oral or documentary evidence would not assist the court to arrive at a proper conclusion. If the report of the commissioner is on record, it would be of a great assistance to the court, and accordingly, the court had allowed the IA and set aside the impugned order by appointing the commissioner and counsel appearing for the petitioner submits that. As the case is also arising out of similar circumstances, hence, in this case also, the impugned order needs to be set aside. And in the interest of justice, the IA needs to be allowed to protect voters, to effectively adjudicate the dispute between the parties. Next para. This matter came up before this court on 21/1/2025. Even on that day, there was no representation for the respondents. Heard the counsel for the petitioner and posted this matter as part heard today. Today also, there is no representation. Even on the earlier occasions also, there was no representation on behalf of the respondents, as this is a writ petition of 2018. Sufficient opportunity is given to the respondents. This court is proceeding with the matter. Next part, having heard the learned counsel for the petitioner, there is entire material on record. This is a it's a suit of the year 2009. The relief that is sought is a mandatory injunction, a permanent injunction, stating that the defendant has encroached a part of the plaintiff's property and he has to be put in possession of the property. Right from 2008 till 2018, the parties have let in their evidence and after after the trial has completed, after the plaintiffs and the matter is posted for the evidence after the evidence posted for arguments and after the argument of the plaintiff is concluded, then when the matter is posted for the arguments of the defendants at that point of time, this application is filed. The submission of the learned counsel for the petitioner as the defendant has stated that he has no objection for appointment of an advocate commissioner. The court ought to have allowed the application. Also, this court is not able to appreciate if appointment of an advocate commissioner is required for the effective disposal of the case. It should have been filed at an appropriate point of time. In every case, filing an application at a later stage, it all depends upon the facts and circumstances of the case, and it's a discretion that has to be exercised by the court. The judgment that the learned counsel is relying on in the facts and circumstances of the case, the judge has exercised a discretion and allowed the application for appointment of the commissioner, the facts and circumstances, and not the facts and circumstances. This court is of the considered opinion that the court had rightly considered the application, had dismissed it on two grounds. One is at a later stage and the other with regard to collection of evidence. On both the counts, this court is of the view the order passed by the court is a well-considered one and there are no grounds to interfere.
Great, minutes.
Case number 4.
I beg to appear for petitioner, my lord.
Ayakiran,
In this case, my lord, petitioner is a defendant
Guru
and
Prasad,
plaintiffs are, my lord, filed the suit for partition. he is a bona fide purchaser, my lord. And they are unable to prove, my lord, whether they are in
No,
joint
you said
position
the
or
suit
joint
is-
family property.
Suit is for
But-
specific performance.
The suit for, my lord, filed for partition, my lord.
Suit for partition.
Yes,
Not
ma'am.
the,
I am bona fide purchaser, ma'am.
not the purchaser.
Yes.
What is the IA?
IA filed to lead the evidence by the defendant only. Until and unless they prove, my lord, because this property was purchased in the year 1996, my lord, how can now at this stage they want to say it is a joint property and joint construction, joint portion, they are enjoying the property, my
Please
lord.
come to the IA.
IA, yes, ma'am. IA at page number, my lord. Annexure C, my lord.
Come to the order.
Memorandum, the advocate filed, my lord. 20, page number 20, annexure C.
You are arrayed as defendant number?
Defendant, no, defendant only, my lord. Only one defendant. For the reasons stated accompanying memorandum of facts,
No, you are
applicant-
saying that it is suit for partition.
the advocate has filed, my lord, memorandum of application, my lord, stating that let them defendant to lead the evidence, whether he is a bona fide purchaser or not. And this particular sale deed is not questioned, my lord. Only 1/6 partition has been claimed. Let them prove their whether they are joint family property or not. Page number 21, my lord, affidavit filed by the advocate. Partition suit for on the ground of property originally belonged to their mother, and upon her intestate death, they along with the defendant are co-owners of the same. Defendant has contended that he has purchased the suit scheduled property from his mother under deed of sale 7/5/2007. Valid consideration has been paid. In view of the above contention, specific issue IA number 3, issue number 3 has been framed, casting burden on the defendant to prove the same. It is submitted that defendant is able to prove said issue, then the plaintiff will be automatically non-suited. If the defendant is unable to prove the said issue, then the suit for plaintiff is to be decided as per the relationship of parties and interstatement. Deviki are admitted, hence appropriately. This is the application has been filed. Now, my lord, the suit scheduled property, I am bona fide purchaser, I have paid the consideration amount. They have to establish that it is an invalid sale deed and it is a joint family property. Why should I lead my evidence, my lord? Therefore, I am before this honor. Now, only with an intention to delay tactics, my lord. The reason has been assigned, my lord, at annexure D, my lord. Annexure E.
Oh, issue number 3 is framed. You never had any issue with regard to framing of the issue.
Yes, my
As
lord.
per that issue, the burden is cast upon you to prove
Yes,
that.
that is, my lord. Until and unless they prove that it is a joint family property, my lord.
What is the issue number 3?
Issue number 3, my lord, I have to establish that this bona fide purchaser of the property, my lord.
So that issue, as far as that issue is concerned, burden lies on whom?
Burden lies on me, my lord, but until and unless first issue, they have to prove it is a joint family property or not. Whether Deviki is having right over the property or not, my lord, that is
Is it your
the,
case that it is not a joint family property?
the plaintiff ought to have to prove, my lord.
No, is it your pleading that it is not a joint family property?
But they have claimed, my lord, for partition
Please come
160.
to your, please come to your written statement. Where
Yes,
is the
ma'am.
written statement? At page 15, come to the written statement.
Yes, my lord. Para number 3, my lord, it is true that aforesaid Srimati Devaki died intestate on 21/3/2009, leaving behind her children of the plaintiff and defendant as per sole surviving legal heirs. However, her intestate death has nothing to do with the property in question, which has been purchased by this defendant as per registered sale deed dated 7/7/2007 on such and such date. Valid consideration. It is true that her husband Mahalinga had predeceased her on 27th, 1996. He denied that. Hence, the death of Devaki, the plaintiff and defendant, being her children, acquired 1/6 right each in the scheduled property. It is denied that the each plaintiff has 1/6 right in the scheduled property or not. It is denied that the death of the Srimati Devaki defendant had looking after the scheduled property with implied consent of the plaintiffs. It is denied that the plaintiffs defendant are joint and constructive portion of scheduled property as co-owner. It is submitted that at any time question of the joint and constructive portion of the scheduled property by the plaintiff with the defendant never arose at all, since the defendant is absolute owner by virtue scheduled property as per sale deed dated 7/7/2007. The question looking after the scheduled property with implied consent of the plaintiffs by the defendant and they being joint and constructive portion of scheduled property as co-owner does not arise at all. This is only property, my lord. It is has been, she was looking after that particular property. Therefore, does not mean that this property is belongs to Devaki independently. She has got independent right. She has sold the property, my lord. Now, after death, my lord, immediately they are coming saying that this property is a joint possession of joint family property. Since from 2007, my lord, 2014 suit has been brought by raising the cause of action.
Please come. Agreed with the orders passed in I number 4 in OS number 1060 of 2014 dated 21/6/2019. The defendant is before this court. The plaintiff, the respondent herein, the respondent herein, who is the plaintiff, has filed the suit for partition. This is a case of the plaintiff that the suit scheduled property belongs to the mother of the plaintiff. has been acquired by the mother of the plaintiff and defendant as per terms of deed of partition deed dated 1/1/1996, registered as document number 3368 of 1995-96 with the office of the sub-registrar Bangalore. During her lifetime, she had been in absolute possession and enjoyment of the property without any claim or hindrance. She died intestate on 21/3/2009, leaving behind the children, her children, that is the plaintiff and the defendant, as a sole surviving legal heir. The father, that is the husband of Srimati Devika, had predeceased her on 27/1996. Hence, on the death of the mother, the plaintiff and the defendant, being the children, acquired 1/6 right each in the property. And the plaintiff has 1/6 right in the scheduled property. An issue is framed whether the defendant is a bona fide purchaser of the property or not. Then an application came to be filed. Under the 18-1 CPC, directing the defendants to commence evidence. Is the case of the plaintiff that once the defendant proves that he is a bona fide purchaser, then the plaintiffs can be non-suited. And the entire case can be, their suit itself will be dismissed. And they will reduce the rebuttal evidence. The court, by order impugned, had allowed that application. And court observed that in lieu of the issues framed by bestowing burden on the defendant, the plaintiff is at liberty to lead rebuttal evidence on issue number 3. In the touchstone of reasons assigned, the court had allowed the application. The aggrieved thereby, the defendant is before this court, and then counsel appearing for the defendant submits that when the suit is filed by the plaintiff seeking partition in separate portion, and it's a case of the defendant that it is the property of the mother, and he has purchased the property from her. The burden lies on the plaintiff to prove that it's a joint family property. That burden has not been discharged by them, and court cannot direct the defendants to lead the evidence. And in fact, the burden is cast upon the defendant by passing this order. Next slide. On 21/2025, when the matter came up, there is no representation on behalf of the respondents. And this court had heard the counsel for the petitioner and listed this matter as parted. Today also there is no representation. Even on 9/1/2025, 37/2024, also there is no representation on behalf of the respondents. It appears that the respondent is not interested to pursue the matter. Next paragraph. Having heard the learned counsel for the petitioner, there is the material on record. The suit is filed seeking the relief of partition. According to the defendant, he has purchased the property, and the mother is absolute owner, and it's not a joint family property. When the plaintiff had come before the court seeking that it's a joint family property and is seeking partition, first of all, the burden lies on the plaintiff to prove that the property is a joint family property, and without discharging the said burden, the court cannot ask the defendants to lead the evidence and the order impugned is contrary to law. The same is liable to be set aside. Accordingly, the order impugned dated so accordingly, this court is passing the following order. The order impugned dated so and so is set aside. Is set aside, and consequently, IN number so and so is dismissed. Accordingly, the petition is allowed. Next.
For dismissal, serial number 5. A.S. Narayan Swamy.
For the
for
petition in
petitioner.
this case, my lord, in the present petition, I have challenged an order passed in the OS. The
Non-amendment of the cost title.
my lord, the suit is itself is
is
disposed. I am filing a memo along the status.
decreed.
But it is settled in the Lok Adalat between the parties. My lord.
A memo is filed stating that the main suit that is OS number 1800/2007 has been settled in the Lok Adalat on 13/7/2024. It is submitted that in view of the as the suit itself is disposed of, nothing remains for consideration before this court. The same may be dismissed as infructuous accordingly. A memo is taken on record and the writ petition is dismissed as infructuous. Next.
Serial number 6.
Lord, the petition,
Mr. Riley.
or the petitioner, my lord. Lord, the petitioner had filed a suit, my lord, for defamation, my lord, against respondent number 2. My lord, after some time, my lord, before recording of the evidence, my lord, suit was withdrawn. My lord, also be kindly see the memo, my lord, filed in the suit, my lord.
Who does which year?
My lord, suit, my lord, is the year 2014.
You have filed a suit for defamation. You are the plaintiff.
Yes. We have filed, my lord. My lord, subsequently, my lord, on
On when?
7/3/2019.
7?
3/2019, my lord. And my lord, a request was made for a refund of court fee. In that memo, my lord, you'll also may kindly see, my lord, page 21 is the memo, where my request was made for refund of the court fee, my lord, as
Page
since
20?
21, my lord. Annexure B, my lord.
Hmm.
The plaintiff is not interested to continue this suit, hence I filed this memo not pressed. The suit has dismissed in the above case. Wherefore, the honorable court may please to refund the entire court fee in the above case.
Then
My
what
lord.
did the court do?
My lord, court, my lord, has declined to refund the court fee, my lord, and the reasons, my lord, the section 66 of the Karnataka Court Fees Act, my lord, does not have any provision to refund the court fee. My lord, lordship may kindly see, my lord, the reasons of the court, my lord, in page 9, my lord. Para 4.
Let's look at that section
My lord,
66.
section 66, my lord.
63 to 69.
66 is, my lord, the relevant provision.
That court fees are
Karnataka Court Fees and Suits Violation Act, my lord.
60?
66, which
Refund
provides for
on
refund of court fees.
That is refund on settlement.
Yes,
Before
my lord,
hearing.
regarding 66 clause 1, my lord,
Yes.
it is, my lord, on refund on reference on sections 88(9) of CPC. That is, my lord, for mediation other proceedings. Then, my lord, 2, my lord, in cases not covered by subsection 1, whenever by agreement of parties, in number A, my lord,
You're
any
reading-
suit is dismissed as settled out of court before any evidence has been recorded on the merits of the claim, my lord. My lord, A, my lord, in this case, my lord, we
They
rely
will
upon.
not apply.
My lord, in this case also, my lord, evidence is not recorded. But my lord,
No. Any suit is dismissed
As settled out of court.
settled out of court before any evidence has been
Yes, ma'am.
recorded. On this
Here, my lord,
provision itself starts with refund on settlement before hearing. Settlement is something else.
no, before recording of evidence, my lord, this is.
Any
Before-
suit is dismissed as settled out of
Out of
court.
court, before any evidence has been,
No, it is not your case that it is settled out of court. You just want to withdraw.
no, it's withdrawn, my lord, though, my lord, the parties never intended to press the suit, my lord, it was withdrawn. But, my lord, in the memo, my lord, it was not mentioned as settled out of.
Withdrawing is different. If you have settled and withdrawn, then it would have been recorded by the court that the dispute is settled between the parties. In view of that, the suit is dismissed as withdrawn or something. But it is not the case here. You
Yes.
filed the case. You want to, for various reasons, you want to withdraw it. Then
Yes,
how
ma'am.
do you fit in this 66?
my lord, I'm relying on one decision, my lord, of this honorable court,
Please
my lord,
pass it.
where, my lord, that was a case, my lord, where it was half court fee was refunded. And my lord, this court, my lord, has refunded the full court fees, but that was a case, my lord, of, in the memo, my lord, it was settled as dismissed. My lord, your lordship may kindly see, my lord, para, in page 4, my lord, para 7.
Yes.
The suit is for recovery of money. Section 21 of the KSCF and this SV Act provides that court fees shall be computed and amount of claim, and the plaintiff has to pay court fee of 4 rupees so and so. Even before the defendant filed written statement in the suit was withdrawn as settled out of court and the suit was dismissed.
That's what. If your case also falls under that, then no
The
problem.
only thing is, my lord, we have not mentioned, my lord, it is not settled.
Yes, the
It's
whole
only pressed.
purpose is,
But here, my lord, the memo was filed, my lord, as settled out of court. Only difference, my lord, since it is settled out of court.
court
here,
case is not
it is
about
not
something
pressed.
settlement. You don't want, for various reasons, you file a suit. You don't want to pursue it. After some time, you realize and you just like that withdraw on your own. You will not fall under 68, 66. Court was right. Please come. The agreed with the order dated 15th July 2019 on the memo filed by the counsel for the plaintiff dated 15 July 2019. The plaintiff is before this court. The petitioner plaintiff had filed OS number 219 of 2014 against the respondent seeking the for defamation. Thereafter, he has filed a memo. Thereafter, he wanted to withdraw the petition, withdraw the suit. And he came up with a memo stating that the plaintiff is not interested to continue the suit. Hence, he has filed the memo not pressed and the suit may be dismissed and to refund the entire court fees in the suit. That came to be dismissed by the court by order impugned, wherein the court observes that in the memo it is not stated that the dispute is settled between the plaintiff and the defendant either by invoking section 89 of CPC or by way of settlement outside the court. Chapter 7 consisting of section 63 to 69 of the KCF and SV Act 1958 deals with refunds and remissions of court fees. The contents of memo filed by plaintiff does not fall under any of the circumstances narrated in chapter 7 of the Act so as to order for refund of court fee, and accordingly the court has partly allowed the memo and dismissed the suit as not pressed, but however held that the plaintiff is not entitled to refund of the court fee. Learned counsel for the petitioner had drawn the attention of the court to section 66, and he submits that as for section 66A, section 66A says that any suit is dismissed as settled out of court before any evidence has been recorded on the merits of the claim. It is a contention of the counsel for the petitioner that in this case also no evidence is latent, and he has withdrawn the suit. As such, he falls under 66A, and the court ought to have returned the court ought to have refunded the court fees. He relied on an order passed by this court in writ petition number 33768 of 2009 in case of Sri R. Prakash and Sri T.M. Ravikumar and other, dated 3rd February 2010, where this court had allowed the writ petition and directed the trial court refunding the full court fee, where in that case the court had refunded only the half of the court fees. Relying on this judgment, learned counsel submits that even in this case also, he's entitled for the refund of the amount which was not considered by the court. Next para, there is no representation on behalf of the respondents. Having heard the learned counsel of the petitioner, there is a material non-record. The suit is filed for defamation and in the year 2014, and the petitioner wants to withdraw the suit in the year 2019, and hence came up with a memo to dismiss it as not pressed and for the refund of the amount. For refund of the court fees, section 65, 63, chapter 7 deals with refunds and remissions. The plaintiff is relying on section 66, which is refund on settlement before hearing, where he is thrust upon 66A, wherein it says that a suit is dismissed as settled out of court before any evidence has been recorded. Just because evidence is not let in and he has withdrawn the case, at any stretch of imagination, it would not fall under the chapter 7 refunds and remissions, and in particular, section 66A of the Act. A case which is settled out of the court, any compromise that is ended cannot be equated with a withdrawal of the case, and the purpose behind this section is altogether different. The judgment that he has relied on in case of Sri R. Prakash referred to Sutra is a case where the suit was withdrawn as settled out of the court, and the said suit was dismissed. Even on the facts of, on the merits, on the facts also, the facts of the said case do not apply to the facts of the present case. Accordingly, the writ petition is dismissed.
For orders matter, cell number 7.
Yes.
My lord,
Yes, Mahadevan.
my lord, 7, my lord, I have taken steps, my lord. Already I'm 110, my lord. I have taken steps on,
Why has it come today?
my date was given, my lord, that is why it has.
So, you already taken steps when?
10th January.
And it is submitted by the petitioner, on behalf of the petitioner, that already steps are taken. This is matter after service.
Cell number 8.
What about this?
My lord, 8, my lord,
Prakash,
is quarters matter, my lord, yesterday.
Huh? What?
My lord, 8, my lord, it can be allowed, my lord, with only one condition. My lord, facts are like this. My lord, it is required to be told. Yesterday, my lord, there was some. My lord, father was an employee. There is a proof that he was an employee. When he was an employee, he was allotted these quarters by the company itself. He was there and paying the rent. So to show that he was an employee and he was allotted a quarter, there is a document. Those documents were not produced by him when he filed a writ petition before company petition earlier, before Justice Bopanna's order. Justice Bopanna has written an order stating that he is not rejected that CA. He has only told that he has not produced the document. If you produce the document, OL is not accepting and rejecting, then you file a case. That is what the order. But by that time, father died. Now LRs are there. LRs also, there are six persons are there mentioned as per the record. Now 2 persons have filed. One father and son and daughter has filed a petition before this honorable court to say. And requirement is, according to my this request is, it can be allotted to sale deed can be given to the son who has filed this application. Son and daughter, they filed application, but application government says that the daughter has no objection, but she has not given no objection in this case.
No, that the deceased is survived by a daughter and a son.
No, there are four, according to this, there are four legal heirs, 6 legal heirs.
Then why only two
No,
of them?
that is why. If a son wants an allotment, then other legal heirs, if they give no objection to the official liquidator, I have no objection.
What we do is, let me not pass any order because it keeps on going. Let the petitioner come along with all of them before the court. The applicant, let him come up.
If they give indemnity bond also is enough, because
Please let them, do
whatever
it.
it is.
Let
Yes.
them do it before the court.
Yes.
And then we'll pass an order.
I have no objection for.
We'll pass over so that if once the advocate is there, we'll ask him to come. Advocate. What is saying?
He says he is there in another, is there in another court he wants to pass over.
Let him come. Only same order. I'll ask them to whatever are required. Let all the legal representatives be before the court.
Because
then
he has produced
accordingly
the
pass an
he has
order.
produced a legal
So that
asset.
there won't be any other
Yes,
complications
yes.
thereafter.
That is all of the. Yes.
Pass over.
Sale
Yes,
number
next.
9, adjourned, sale number 10. Sale number 10.
My lord,
Cohen.
I have to attend another case, my lord, I have to go in person.
Not necessary. Your presence is not necessary in that earlier case.
Blood in this.
Appeal for the petitioner.
Of subjects have been complained, bloods. In this matter, blood.
IA number, office objections raised on IA number 1/24 for release of amount filed by advocate for respondent not complied.
That's been complained.
On submission.
It has come on record, blood.
Copy served, acknowledgement not filed. That's the only objection.
Copy is
Yes,
not
yes, my
served. On submission.
Acknowledgement
my
also.
lord,
I have.
Not served today.
Not.
No, acknowledgement also served, they have the cop. acknowledgement also.
I am the counsel, not served.
Who is give it to him if you have to give.
Yes, I'll,
On the
sorry,
petition.
copy.
Hmm.
On submission, my lord. So already the matter was stayed in Chennai High Court because of the jurisdiction, the original suit pending before the civil court in Chennai. Thereafter, I filed the entire order sheet. After granting stay order,
Have you given it to him? Have you served on
No,
him?
not served.
sorry.
Serve him a copy. He will serve the papers to you. Then we'll hear it. This
Okay.
is matter on
Kindly
Thursday.
peruse the page number 4.
This is matter on Thursday.
Page number 4.
A memo is filed by the petitioner. List this matter on Thursday. You shall serve the same on the council
Public.
hearing for the respondents. And the respondent council has served the
Copy of,
copy of IA number. What is that?
for
IA
release
number
of.
1/2024 on the council for the petition. You have taken, as he served.
I served, yeah, served the copy.
I served.
I'll serve the copy.
Yes.
Sale number
Do it
11.
right now.
Right.
This is matter on Thursday.
Now the matter is pending in the High Court, in Chennai High Court
We'll
with the
see.
stay.
We will see.
Okay.
He has to.
Yes,
look at
yes,
it.
I will.
Yes.
Sale
Detail.
number 11, Ajay Jain for petitioner, Rakshit Joish.
I appear for respondents, my lords. Respond number 4 is dead, and you filed a memo.
You have given all the details.
Yes,
particular-
I have personally also
The-
given the details to the
A
petitioner.
memo is filed stating that after is no more, then counsel for the petitioner shall take steps within.
Milas, I appear for the petitioner, Milas. We've just got the details. We'll take steps, Milas, 2
Take
weeks.
steps by 10th of March.
This is serial number 11, Milas. I'm sorry, I missed.
Yes.
Sale number
Yes.
12,
Thank you.
VB Shivakumar for petitioner. None for next year, correct address for third. Okay, for petitioners.
Yes.
Are we memo withdraw?
You want to withdraw?
Yes, ma'am.
Take that. A memo is filed seeking to withdraw the writ petition. Memo is taken on record and dismissed as withdrawn. Next.
Sale number 13. Channappa.
Your Lordship, I pay
Chenna,
for a short
please.
accommodation.
A week's time is granted, same default order.
Your Lordship, there's an interim order, maybe kind.
Amendment of the cost title. Intermodal for extent. Yes, next.
Sale number 14, GS Venkat Subbarao for petitioner.
Office objections to be complied with
2 days minimum.
within 2 days. If it is complied with, listed immediately.
Sale
Yes, next 15.
15.
Correspondent 7. Already complied the office objection. Full fast title they have asked, we have complied. And delay days also we have mentioned, we have complied the office.
Then why have they mentioned it again? Look at it.
Notice may be added to the LRs of the deceased.
Let's see first
Please,
is that
please, Miller.
defects have to be cured. The office objections shall be complied with within 2 days. If the same is complied with, listed immediately.
Sale number
Interim order may be
16.
kindly be extended.
Look at it. In all the matters, whether I tell or not, if there is interim order, extend or not, if it's not there. Yes,
Sale number 16. Chandana Tariga for petitioner.
Petitioner.
yes.
There are 2 objections raised on my application. That is, one is for mentioning the delay days and the other is copy to be served on the other side. Petitioner number 6 passed away, my lords. I filed 3 applications. I've served copies on them. The only objection that need to be cured is mentioning the delay days. I shall mention it right now if may be permitted. Please.
Where are the respondents?
Cyril Prasad Payas for responding.
The respondent has filed another writ petition where he is the petitioner.
No notice needs to be ordered or he'll take notice for the.
Well, I am for the petitioner in the first matter. In the second matter,
You want to use some LR application is filed.
I have filed and no notice need not be because
Petitioner number 6.
petitioner number 6 passed away. His LRs are.
That is.
A memo is filed. And where is the LR petition?
That's the LR application filed on 14/10/2022.
Petition number 6.
The death certificate is a memo.
That's death certificate is there. There is
Where is the IA for that?
one IA seeking set-asiding of abatement. The other one is for bringing the LRs on record. All 3 are filed on 14/10/2022.
It's the petitioner. Yes, give that. How much is the delay?
282 days, my lords.
282.
82.
Who appears to the respondent?
Respondent.
Respondents allowed.
Yes, will condone the delay.
The connected matter.
I number
1 of 20.
1, 2, 3. I number orders in I number 1, 2, and 3. The sixth petitioner died and the I is 5 to bring the LRs on record. And there is and to condone the delay of
282 days, my lord.
282 days and to condone the delay of 282 days and to set aside the abatement. This court has perused the affidavit filed in support of the applications. Accordingly, the delay in filing the application to bring the LRs on record is condoned. Abatement order of the abatement is set aside. Abatement is set aside. And the LR petition is ordered. The petitioner shall carry out the conveyance to the cost right.
The connected matter, there is.
What about the connected matter?
Same matter is filed by the respondent.
Respondent. And they have to come up with the application.
Like, please, my lord, they've reported, based on my memo, they've reported the death of respondent number 6 therein.
Then when are you going to file?
I will do it by next
Huh?
week. The next date of hearing will be.
2 weeks' time, it's finally granted to bring the alerts of the, you're the fourth respondent then, sixth
Please.
respondent.
Well, it's I'm for all the respondents over there.
No, who died there?
There's respondent number 6 passed away.
To bring the alerts of the sixth respondent. Finally, a 2 weeks' time is granted. Or else the petition shall stand dismissed as far as the, as far as the
Regarding the
respondent.
amendment, kindly permit me to carry out the amendment
Is it-
today, please.
Yes,
Number 17.
no, but this say, they take steps with it.
But a memo of
Default
retirement.
order, the petition itself stands. Is 17,
17.
I have heard a memo of retirement in this case.
take that.
Madhva
Petition has become impetuous,
What has happened? Suit is,
dismissed.
you have the proceeding?
Yes, my lords. Online copy I have, 11/9/2024.
Where is that? Take that. It's a plaintiff's revision or a defendant's revision?
Plaintiff's petition.
Plaintiff's petition. The suit is decreed.
Dismissed.
The memo is filed. But you have to file all the documents just like that. How can the memo for retirement be accepted?
The partition signature is there.
Huh?
I take a signature of the petitioner.
Where is that?
The one, the original I filed in the court, in the court. In my office copy, did not put up. ಅಲ್ಲ, put up ಆಗಿಲ್ಲ ಅದು. On 17th I have filed it, but it's not put up in the.
Yes, filed it seems. Then counsel for the petitioner filed a memo of retirement stating that he has already given up wakalat. Given up wakalat. Then counsel appearing for the respondent has placed before this court the case status whereby the suit, that is OS number 5321 of 2013, is dismissed on 11/9/2024. Accordingly, considering the same, the writ petition is dismissed as infructuous, and before that, the counsel for the petition is permitted to retire.
Yes.
Yes. Yes. Yes, next.
Serial number 18.
My lord, serial number 18, my lord.
Yes,
The
18.
counsel, Sri J.G. Chandramohan is no more, my lord. He is died, my lord. Kindly issue court notice to the petitioners, my lord.
Is submitted to the counsel for the petitioner. Mr. Chandra Mohan J.G. is no more. Registry is directed to issue notice to the parties. Yes, next 19.
Serial number 19.
On serial number 19, I represent the petitioner.
Yes.
That's contesting respondent, my lords, is the respondent number 1. And my lords, they are contesting it. But since court notice has been issued, and even before the trial court, they are not
No, if
appeared.
they are not necessary, then file a memo.
I will file a memo today itself during the course of the day.
Tomorrow,
Maybe
tomorrow
it may be.
Tomorrow we'll take.
Please, my lords. Suit is of the year
The counsel
2006.
for the petitioner submits that the contesting respondent is already on record. Is already represented by an advocate, and other respondents are not necessary parties for this application. He submits that he will come up with a memo. This is matter tomorrow.
Please, interim order may kindly be extended.
Interim order earlier granted is extended till tomorrow.
I'm grateful.
In the memo, my lord. So far as respondent number 1, 2, 3, and 5, my lord, they are the formal parties, my lord. The aggrieved parties are the respondent number 34 to
What
39.
is this dismissal of writ petition dated 21/1/2024?
That is, my lord, for taking a steps insofar as these petitioner, my lord. That steps is
So,
not necessary.
Memo is filed stating that the respondents 1, 2, 3, and 5 are the formal parties. And the impugned order is in favor of respondent 34 to 39. And it is stated that respondents 1, 2, 3, and 5 are not necessary parties accordingly, and sought for dispensation of notice to them. Accordingly, memo is taken on record, and notice to respondents 1, 2, 3, and 5 is dispensed with at the risk of petitioner.
And
Next.
IA number 1 to 24 is filed already. It is not present, ma'am, because it is not necessary.
IA number 1 of 24 is dismissed as not pressed. Then
Kindly post it for hearing, my lord. Now, hearing stage, my lord. And summons is served.
tomorrow,
No, next week, my lord. I need to some research. Therefore, next week, any date, my lord, I will get to the date.
you're doing the research from 19.
No, I will research, my lord, but any date, my lord.
This
Tomorrow, I
matter
have
on
some-
Wednesday.
Please, my lord.
Yes.
29-1. Serial number 21. Then
Lords, in this, the first office
Then-
objection pertains to insufficient address being furnished to the respondent number 3, my lords. But if my lord sees the applications filed by the very respondent number 3, which is at page numbers 40 onwards, my lord, of the
Yes.
petition, it's the exact same address, my lords. And they filed that in the very, just about 3 months before that, my lords.
Come up with with a substitute service, with an application, so that.
Allah, because the other side of it, my lords, is the R3 and R1 are related. The R1,
No, that apart. No, your R2 is
my allegation is that they're colluding with each other. The plaintiff,
R2 is
R2 is served.
pending, it's a pending suit.
Yes, my lords,
Take out hand summons on the counsel appearing for the respondent.
please.
Respondent 1 and 2.
No, 1 and 2 is already, 1 is already represented, my lords. R2 is served, R2 is no appearance. R3, my lords, it says insufficient.
Petition is permitted to lend counsel, the petition is permitted to take out hand summons on the counsel appearing for respondent number 3
3,
before the trial court and file a memo to that effect by
1 week's time, my lords.
shall file a memo by 4th of February.
Insofar
memo
as
is-
IA, the second
The
office
memo
objection,
is filed, it will list on 5th.
please, my lord. But apart from that, there's one more office objection that IA 16 and 17 are to be produced, my lords. I have those, my lords. May I pass it on?
No, do it.
I'll
any
file it
other
in the
time.
counter.
The other objection shall be complied with by then. Yes, next.
And one more housekeeping issue, my lords. The interim order may kindly be extended, but apart from that, the name of N. Kiran for the petitioner may kindly be deleted, my lords. And my name may be shown correctly, Surat Sampath, my lords.
That Mr. So-and-so, write your name on the picture. Mr. So-and-so has filed a wakalat.
I've been on record from the beginning, just that N. Kiran may be deleted and my name may be shown correctly.
That it is submitted that so-and-so is appearing. And delete the name of Ms. N. Kiran. And the name of so-and-so shall be reflected in the cost rate. In the case, in the cost rate, in the cost list. Yes.
Interim order may kindly be extended.
Look at it, if it is extended, then
serial number 22.
Okay.
Rajeshwari TS for petitioner.
this court by order dated 29/8/2024 has directed the family court is dispose of the matter as expeditiously as possible, but not later than 6 months. But later than the hence the learned judge giving reasons as requested for a further period of 6 months. Considering the same, another 6 months time is granted for disposal of the pending ones. Yes, next.
Chair number hearing on interrupted application 23, Rahul S. Reddy. For petitioner, KV Narasimhan,
I appear for the respondent,
respondent,
seeking for a short accommodation.
Who is appearing for the petitioner?
I appear for the respondent,
You appear
for the petitioner, my lords.
Mm.
Short accommodation, my lords.
Why?
On-record counsel is held up in another court, all my lords. Or pass over the matter, my lords.
Then pass.
Please, my lords.
Short accommodation is adjournment.
Yes, my lords.
Pass over.
Please, my lords.
chair number 24, 25 adjourned. Chair number 26 for preliminary hearing, Chandana Tariga K.
Respond. Petition. May it please you. My lord,
Puna Shetty,
this is a plaintiff's petition against the rejection of an application for injunction. My lord, it is in respect of 1.54 acres of land in survey number 105 of a village called Chara. My lord, to prove his possession, the plaintiff, I'll just narrate, my lord, these documents are before the court. To prove the possession, he has placed the Sagwali chit, that is the grant certificate.
Have I heard this matter before?
No, madam. No, madam. This is not heard. This man was in occupation of a
No,
particular.
both the courts have concurrently dismissed the
No, madam.
application. for
No.
grant.
First court,
Has granted.
yes, first court, based on the records, which are all these records, has come to the conclusion that he is in possession of the property.
Hmm.
The first appellate court says that Sagwali chit, that is the grant order made in favor of my client, is questioned, and by the other side, that is the defendant, since it is questioned and stayed, the injunction cannot be granted. My lord, what was questioned and stayed is before the KAT, that is the grant certificate. But as far as the possession is concerned, all these documents would prove the fact of possession. That first appellate court has not.
Interim order is there in this?
No, my lord. There is no interim order because
The suit is of which?
the suit is of the year 2000, my lord, 1 second. Yes, 2000, not 2018. OS 45 of 2018.
What is the stage of the suit?
The
now?
stage of the suit is it is posted for evidence, madam. On 30th of this month, it is posted for evidence. It was earlier posted for evidence on 20.
So injunction, you have no injunction from 2018.
18, but I'm in possession. I'm in possession. Because possession is reflected by all these documents,
No, that is-
proceedings,
That is
please, ma'am.
true, right from 2018 till 2025, you are without an order.
No, my lord. There was an order in my favor by the,
No, MA is of the year 2018.
yes. MA is of the year
And the order date
2018.
of the order
When
is
the MA order was
9th
passed,
October 2018.
please, my lord, that's
So
correct.
from right October 2018
Yes,
till 2025,
yes.
no order in your favor.
There is no order.
So, if the
Yes.
court dispose of the
But I could gather this is what the court would say, but only.
No, I will record that
Yes.
because it has already now injunction, interim injunction is granted, appellate court had reversed it.
Yes.
And that there is no stay by this court. At this stage, we will not be going to the merits of the matter as it is already a suit which is more than 6 years.
7 years.
7
sorry.
years old. Let it be decided. by
No,
the
that's
court.
fine, madam, but
I will say that I have not I have not even gone into the area of the merits of the matter.
yes.
With regard to the possession injunction or otherwise.
My only request is, my lord,
2018 injunction is not granted,
Purpose of interim injunction is something.
not
else.
granted, but that does not mean that I am not in possession because
So that's why court is not at all recording that. Now, a purpose of interim injunction is to protect the plaintiff's position
Yes.
during the pendency of the suit.
yes,
That stage you have crossed. At least I can understand there is an interim order in this case in the year 2018.
yes.
Nothing.
Oh.
So let the court proceed. I'll say that I'm
My
not
lord,
going into the merits of the matter. Let it continue, however it is.
My lord,
continued.
may I request one indulgence, my lord? Now, matter is going on. Let the status quo as it is, let it be continued till the disposal of the suit.
But-
Otherwise, an interpretation will be given that there is no order of injunction.
So what will happen is,
Yes,
given a chance, they would be saying that they are in possession of the property. You would say you are in possession of the property. Now, how this status quo,
That's the-
without recording the finding to be granted.
that's the reason I may have to draw you, my lord's attention to these records, which has recorded, my lord, to grant a Sagwali chit, that is a grant certificate, we call it here. There should be a proceeding. First, when an application is filed, in that application, I need to say that I am cultivating this land for all these years, number of years. That will be verified by the,
View of the court is unnecessarily you are making the court to, if any observations that
no,
needs to be given
no,
is-
no, no,
yes.
no, 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 no.
If I have to pass orders on the merits of it, you would be inviting an order on merits, sir. At this stage, would not be right for the plaintiff.
My lord, even my lord were to pass such an order, that would come with the rider. All these observation only for the purpose of disposing of this.
There, but
this
always,
writ-
but
writ
always the
petition.
findings that,
Therefore,
whether the takes a clue or not, though, as a formality, we say, court will definitely take a clue from that,
Yes,
like how the
yes.
court had proceeded with it.
Yes, yes.
So I think at this point of time.
No,
without going
therefore,
into
I
that-
thought, and I can, I may be right in seeking an indulgence that let the parties be as it is, as it is. I'm not saying anything, as it is. Let the suit continue.
Court doesn't even say that. It is as it is.
I
from
leave it,
2018.
I leave it to this honorable.
Yes, please come. The suit is for injunction or declaration?
Where injunction? Injunction, where injunction?
The petitioner, the present application, the writ petition is filed. Agreed with orders passed in MA number 5 of 2018 dated 9th October 2018, whereby the appellate court had reversed the findings of the trial court
Annexure P, my lord.
and refused to grant injunction to the interim injunction to the plaintiff. The petitioner who had who had filed the suit for injunction had filed an idea seeking interim injunction. The trial court had granted injunction and agreed thereby. The defendant has filed MF 5 of 2018 and the appellate court had set aside the order of the trial court and dismissed the application of the plaintiff seeking interim injunction. The order in the MA is dated 9th October 2018. Against that order, the present writ petition is filed. In the present writ petition, there is no interim order passed by this court. The suit is of the year, considering the order in the MA, that is of the year 2018. And as we are in 2025, at this stage, this court is not inclined to go into the merits of the matter with regard to the legality or otherwise of the orders passed by the trial court or the appellate court. As is a suit of 2018 and a suit for bare injunction. In this bare injunction, this court is of the view that there shall be a direction. And if a direction is given to the trial court, it will serve the purpose accordingly. The court is passing the Following order. The writ petition is disposed of, directing the trial court to dispose of the pending suit as expeditiously as possible.
Obliged.
And it is made clear that the court has not expressed any views on the merits of the matter
Please, madam.
here.
Appeal number 27.
Yes, 27.
Appearing for petitioner, my lordship.
I have the cost. Deepak. I have the cost in my hand, my lord, regarding 5,000 rupees cost.
Yes, yesterday costs.
I shall file the acknowledgement in the counter. I'm requesting for the objections to be filed in coming week, my lords. The affidavit is not ready. They have filed an application seeking to transfer the company petition to NCLT.
No, what is this? No, for that, what objections? It's a legal issue.
But
It's a legal issue. Let's not dodge the cases like this. If it's a legal issue, why you want objections for that?
I may be permitted to place my objections on record. my
Who
lord, in
stopped
regard to
you?
the
Who stopped you? Because you're not filing, costs are directed to be paid.
Only difficulty was I was not able to procure the affidavit of the authorized signatory. That is why
First of all, what your client's supposed to do, he's not doing. And for that, he pays 5,000 costs, again seeks for time.
I'm only going to file linking time until Monday, my lords. I will
Oh,
procure the
Let's
affidavit.
just learn counsel submits it as per the order passed by the court. They have already paid the costs. And a memo will be filed to that effect. And on objections for transferring this matter to the NCLT, they will come up with objections by Monday and will not seek further time. List this matter on Wednesday.
Wait for my lords.
Yes,
Appeal number 28.
yes.
Plaintiff's writ petition. On the orders passed and memo, please, my lord. The petitioners or the plaintiff before the trial court filed the suit for the relief of partition, claiming the 2/7 share in all the social properties, please, my lord. During pendency of the suit, the item number 3 of the matter, please, my lord, this is joint family property, has been settled between the family members, and the defined number 1 to 4 have come forward and settled the matter to the plaintiffs. And accordingly, please, my lord, they have paid the money in means of the share. And we filed a memo before the trial court for dismissal of the suit in respect of item number 3, please, my lord. The trial court, instead of dismissing the item number 3, please, my lord, as your lordship may come to the order portion. Page number 25, please.
Can that be done?
Memo has been allowed and further it has been ordered.
That be done.
Sorry,
Can the court do it partially as far as at this point, at that point?
memo for dismissal, please, my lord, it can be, please, my lord.
Let's see, what is the reasoning given by?
Please,
the
my lord. Your lordship may kindly may come to the page number 25.
Yes,
The reasoning at para number 8, please, my lord.
para 6, please read.
Please. The defined number 6 has filed a separate written statement containing that he is the bona fide purchaser in possession and enjoyment of
So
19
this bona fide purchaser in respect of defendant, that is.
different
in
properties.
respect of- Not in respect of you, this property.
This property, not please.
Uh,
Only we filed memo for dismissal of the suit in respect of item number 3. But this defendant has purchased the property in respect of item number,
But still, can, at that stage, can it be done?
no, memo has been rightly allowed, please, my lord, because of your lordship may come to the last portion of the order. The joint memo filed by the plaintiffs and the defendants number 1 to 4 dated 22/7/16 is hereby allowed, and consequently the suit against the defendant number 1 to 4 joint in respect of item number 3 of the scheduled property is hereby dismissed. It is further, your lordship may kindly see. It is further ordered that if at all the plaintiff succeed in the suit in future in the suit item number 3 has to be allotted to the plaintiff's share as far as possible. Your lordship may kindly see this is the wrong order. Because there are 7 items of the social properties. We filed a memo in respect of only one property, and my family members have come forward for settle the matter, and they have paid the money of rupees 25 lakhs to the female daughters.
Be slow, I'm not able to follow.
Please.
Now, there is a plaint, what is that? Item number 3.
3, please,
Property is there.
please.
Now, what is the compromise arrived at and between whom it is arrived at?
Between the family members, please, madam.
Who are they?
Plaintiffs are the daughters.
The plaintiffs.
Two are the plaintiffs, who are the
The
daughters.
plaintiffs, how many are the defendants?
Defendant number 1 is the father of the plaintiff, and the defendant number 5 are the children of the defendant number 1, please.
So 1 to 5,
Please,
1 to 5 are the
Please.
family members.
please.
So what is the arrangement between the parties? What is the settlement?
Item number 3 of the scheduled property was standing in the name of my father, who is the defendant number 1. And during pendency of the suit, he come forwarded for settle the matter and he paid the money of rupees 25 lakhs to the plaintiffs. 12,50,000 each, 25 lakhs, 25 lakhs.
So you have, the plaintiff has waived his right
Only in respect of
the
one-
property, in respect of
One prop-
schedule 3,
Please.
item number 3 of the property.
Please.
Uh,
And the remaining property, item number 1 as well as item number 2 and 4 to 7 of the properties are still existing.
So now what is this order?
And the trial court has passed the orders. If my share has been allotted by my father in respect of item number 3, in future, the plaintiffs have succeeded in other properties, that is to be allotted. That is the order passed by the trial court, please.
I'm for respondent number 5 and 7. I'm the
Amicus curiae,
respondent.
please.
With respect to respondent number 5, I'm still the family member. And what I would like to bring to your lordship's notice is joint.
No,
member-
in respect of item number 3 is concerned, there is a settlement between the plaintiffs and the defendants. Even that defendant number 6 is also not claiming the property. So what is this rider which I am not able to understand?
I have a feeling item number 3 instead of, that must be an error. Item number 3
Because,
must be an error.
because the
memo
defendant,
is allowed.
defendant has paid the amount
Amounts.
to the plaintiff. It should be allotted to the defendant's share.
If I succeed in the suit in future, my conducting the evidence in respect of other properties,
No, 3 is closed.
please.
Please, my lord, I see, my lords, I have 2 arguments, my lords. With respect to respondent 5, who is still a family member, that is defendant 5. And I'm also appointed for D7, who's a subsequent purchase.
Subsequent purchaser, but not with regard to the, no.
Item 3, I
A
am not.
purchaser, a subsequent purchaser, you can have a claim
Please.
with regard to the property which you have purchased.
Please.
How it falls to the share of somebody, what is your entitled for that is a different issue.
Please,
So even D7 has nothing to do.
please.
Now, when the court having allowed an application to, as far as the claim in respect of
3.
item number 3, their parties are bound by whatever is the settlement. This rider is not required.
Please, my lords.
That portion we have sought for the.
You appear for whom?
For 1B, my lords. Respondent.
1B, that is the defendant.
Legal.
Legal heirs of the defendant.
Yeah.
Father.
Father, please.
One
Father
is the
died.
father.
One is.
Father died during pendency of the writ petition and also the suit.
Their LRs
and,
are on record.
Mother is representing on.
We are for the granddaughter, my
Granddaughter,
lord.
my lords.
One submission, my lords, the joint memo, whatever has been filed. D5 has not signed it.
Who has not signed?
D5.
No, settlement in between D1 to 4, please, my lord.
That
D5 has executed the release deed in favor of the family. And hence we have sought for the any relief against our plea.
Making a submission with.
No, it's not like that. That is for D5 to come before the court.
Please.
That's for the D5 to come before the court. Now, D5 is not benefited by this order, nor it is against him.
Please.
What D5 and D7?
They have nothing to do. Now it is between the plaintiff and the defendant.
Please. And
So-
that rider, I still feel it's a error, my lords. Item number 3 has to be allotted to the defendant's share.
As far as,
Please.
no, even that is also not required. Because in the claim itself is
Memo is-
settled in respect of plaintiff item number 3,
Please,
it need not be there.
please.
So then, as far as that is concerned,
That
we'll,
portion is to be modified, please.
I mean, that is their whole writ petition also.
please come.
But one more submission, my lords, if I may. Since it's a compromise memo, my lords, they have to seek remedy there only, my lords. They have alternative.
No, it is not about, that is not about the compromise order. It is about the mention of the court. Compromise memo, they are not seeking any amendment to the order passed by seeking any amendment on the compromise. It is an addition by the court,
Please.
which they have not recorded in the compromise.
Which were not stated in the memos.
Court's addition to that. So they are not seeking any alteration of
with
the.
respect.
aggrieved by the order dated 3/2/2017 in OS number 18 of 15 by so and so. The plaintiff is before this court. The suit is filed seeking partition and separate portion of the separate portion, and also seeking 1/2/7. 2/7 share in the suit scheduled properties. The suit scheduled properties are item number 1 to
7, please.
7.
item number 1 to 7. Plaintiff and defendant number 1 to 5 are the family members. 6 and 7
Bona fide.
are the subsequent
7
purchasers who has purchased suit item number
1, 2, 4,
2,
7.
7,
1, 2, 4,
2, 7.
4 to 7,
Please.
except item number
3.
3. Other properties are purchased by defendant number
5 to
6
8.
and 6 and 7. 6 and 7.
8
In respect of item number 3 of the suit scheduled properties, there was an arrangement.
That's 8 different.
8 also, please.
8 is also there, 8. So 6, 7, 8 are the subsequent
Please,
purchasers.
please.
In respect of item number 3 is concerned, there is no claim with regard to the purchase. And the father, that is defendant number 1, had paid an amount of rupees 25 lakhs to the plaintiff. And the family members have entered into a compromise, and a memo is filed before the court stating that the adjoint memo is filed with the plaintiffs and defendants number 1 to 4. And the suit again is the defendant number 1 to 4. In respect of suit item number 3 is dismissed. And as per that, the property is, as per the said joint memo, the property is allotted to defendant number 1.
Please.
The property is allotted to defendant number 1. But in the order, it is observed that the joint memo filed with the plaintiff and defendants number 1 to 4, dated 22/7/16 is allowed, and consequently, the suit against the defendants number 1 to 4, joint in respect of suit schedule, item number 3 is dismissed. Further, it is ordered that if at all the plaintiff succeeds in the suit in future, the suit schedule item number 3 has to be allotted to the plaintiff's share as far as possible. Learned counsel for the petitioner plaintiff submits that the court, without any basis and contrary to the joint memo filed by the parties, has passed such an order. This court had appointed Srimati Archana KM as amicus curiae to represent respondent number 5 and 7. And the other family members are
Sir, please, not unrepresented.
and other family members, as far as 1A is concerned.
1B, my lord.
1B.
B.
You,
B,
both of
yes.
you. As far as 1B is concerned, is represented, and the other family members, though, or served, are not are unrepresented. Learned counsel submits that the court, without any basis, is considered contentions are recorded. Recorded is contentions already. Have I dictated the contentions of the petitioner? When counsel appearing for the petitioner submits that there could not have been such a finding by the court contrary to the joint memo. When counsel appearing for the respondent family member, that is 1B, also does not deny the fact that as per the joint memo, also submits that as per the joint memo, the property as per the arrangement and as per the understanding and the compromise, it is allotted to the defendant number 1, that is the father of the petitioner, now is represented by the wife.
Wife and the granddaughter.
A wife and the
Granddaughter.
granddaughter. Then counsel appearing for the learned amicus curiae submits that she has nothing to do as far as their claim is concerned, it is with regard to the other properties, but not concerned with suit item number 3 of the scheduled properties. And the interest of the defendants 6 to 5 to 7 is not involved in the case.
6 to 6, 7, 8, my lords. 5 is a family member.
6 to
6 to
7.
8, 6 to 8.
Not involved. 6 and 6, 7, but you're appearing for.
I am for 5, my lords. That
5 and 7.
Even 7.
She is appearing on behalf of 5 and
the
7.
only submission with respect to 5 is I am not a part of the joint memo.
5
Even
and
though I
7.
might have.
And as far as that is not questioned that. As far as R6 is concerned, the petition.
In the
is
last
dismissed.
occasion, it was dismissed please, because of the plaintiffs have executed the confirmation deed. Settle the
Dismissed.
matter.
Dismissed. Next one. As rightly contended by the learned counsel, the petitioner, as per basing on the compromise memo, when the claim in respect of the suit item number 3 of the properties is allowed, is dismissed, the plaintiff's claim is dismissed. And as per the compromise, when defendant number 1 pays the amount, the court ought to have observed the court ought not to have observed anything except recording the compromise, adjourned memo as filed by them. As far as the counsel with the counsel, as far as the 5th respondent is concerned, it's stated that she is not, 5th respondent is not a party to the joint memo. If the 5th respondent is not a party to the joint memo, any order that is passed, if she is agreed, if the 5th respondent is agreed, he would have come before, the 5th respondent would have come before the court. And admittedly, no such, no, that is not aside before the court. In view of the same, the writ petition is partly allowed. The order, as far as, look at this, it is further till the end, as far as possible, is set aside.
Great.
Obliged.
Much okay.
Yes.
Serial number 29.
I appear for the petitioner.
Manoj,
The petitioner, please, my lady.
Yeah.
The petition challenging annexure A dated 21/3/2017. It's an order that has been passed rejecting my application under section 65 of the Evidence Act, seeking permission to let in secondary evidence. The petitioner, my lady, is the plaintiff in the suit. So suit for recovery of money against the bank. The bank and the petitioner had entered into an agreement called a merchant agreement on 6/8/2001 and a supplementary agreement. Under this agreement, I being a merchant, I was authorized by the bank to take payments through credit cards issued by the bank. Now, in connection therewith, certain merchandise that I had sold to my customers and through credit cards, later the bank said these are all fraudulent transactions and they debited my account. According to me, that debit is incorrect. I have taken authorization from the bank for conducting those transactions. And this is a point of time before electronic. This is all by manual credit card. So the suit is pending. In the suit, I say that.
Here is the suit.
Suit is an old suit, my lady. It is it is first filed in Delhi, then transferred in 2012 to Bangalore.
Delhi which year?
Oh, Delhi, my lord, is 2005. Then for lack of territorial jurisdiction, because it was transferred here, my lady. Now, I have stated that I don't have a copy of this master services.
Stay is there in this.
Suit is stayed on my petition, but it has taken so long for this matter because they have been avoiding service of notice in this matter. 4 or 5 times I have taken notice.
Objection, the bank would have.
No. That's exactly what I would like to point out, Famila. They say we have the agreement. I have said I don't have the original of the master services agreement and the supplementary agreement. I have produced a photocopy
And I file an application under Order 14 Rule 11 Rule 14 to produce to the direction to the bank to
Let's see
produce.
the impute order first.
Yeah, please. That application is allowed, please. The bank is directed to produce it. They take time to produce it. And finally, they file a memo. Kindly see page 139. Kindly see page 139, annexure M.
That's the impute order.
No. That is the memo. They say that we are unable to trace the originals. Then I file the application on the same day under section 65 and say, now there is an order directing them to produce. They are not producing. Now they say they don't have it. Permit me to let in secondary evidence of the photocopy because they admit the agreement. The learned trial court passes the impugned order. Kindly take page 23 and the reasoning is at page 25. The learned trial court holds that the definition of secondary evidence as defined under section 63 of the Evidence Act and consequently the proposed documents cannot in the eye of law be treated as secondary evidence. We say that we are only attempting to produce photocopies. Photocopies is not something that is permissible under section 63. And if my lady permits me to read section...
Let's come to this reasons.
Please. Admittedly, the proposed documents are nothing but the photocopies, and as such, it is needless to mention here that the same do not fall within the purview of definition of secondary evidence as defined under section 63 of the Indian Evidence Act. And consequently, the proposed documents cannot in the eye of law be treated as secondary evidence. Hence, irrespective of the contents of memo filed on behalf of the defendant company, the proposed documents being the photocopy, no leave as sought for deserves to be granted for the simplest reason that the proposed photocopies do not fall within the purview of section 63 of the Indian Evidence Act. Hence, for the aforesaid reasons, IA under section 65 of the Indian Evidence Act by the plaintiff seeking leave to produce and mark photocopies of the mercantile agreement and supplementary mercantile agreement is hereby dismissed with an observation that plaintiff company is at liberty to pose questions upon the undisputed documents of mercantile agreement and supplementary mercantile agreement as narrated in the application. If I may please see, read section 63. Section 63 of the Evidence Act is very clear. And the bank does not deny at all. I have produced the photocopy. They have seen the photocopy. They have seen.
No, the question of denying is unless and until they have the document with them, how can they say that whether it is there or not?
No. What they do is I say I do not have the original. I say I have only the photocopy. I seek.
You get that they have admitted that this is.
Kindly see the objections to the.
We'll just go to the 63. And
Please. 63. Secondary evidence means and includes 1. Certified copies given under the provisions hereinafter contained. 2. Copies made from the original by mechanical process which in themselves ensure the accuracy of the copy and the copies compared with such copies. Copies made from or compared with the original counterpart. So under subsections 2 and 3, a photocopy which is made through a mechanical process will become applicable as secondary evidence.
And you have to read it with 65 then.
Please. Section 65 is secondary evidence may be given of the existence, condition or contents of a document in the following cases. A, when the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, of any person out of reach of or not subject to the process of the court, or any person legally bound to produce it, and when after the notice mentioned in section 66, such person does not produce it. B, when the existence, condition or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. C, when the original has been destroyed or lost or by the party offering evidence of it.
To come under B according to you?
I will come under A and parts of A and B. They have it, they admit it because it is in their custody. And they say they admit it. And I have laid the foundation as this Honorable Court and the Honorable Supreme Court has said. I have made an application seeking a direction to the bank to produce it. They say we will produce it. On 2 occasions, they file applications for adjournment, which I have produced my Lord's consideration. Kindly take annexure J at page 1.
Now please come to their admission. Where is it?
Please, kindly come to annexure. Then the objections to the application itself. 119, please. 119, which is their objections. They also say so in the written statement. I'll take one of them. Objections, para 3. It is submitted that the photocopy of the document sought for in the present application have been submitted by the defendant along with its written statement, and the same would be produced at the time of defendant's evidence in support of defendant's case. And the plaintiff has got sufficient opportunity to examine the said documents at that point of time, and hence it is not relevant for seeking the same at this stage. It is submitted that the defendant has not commenced his evidence. Further, plaintiff has not mentioned in their application the reason behind the direction from this honorable court for production of the aforementioned documents at this juncture. The defendant submits that there is no urgency at this point of time for production of the documents by the defendant. Hence, application filed by the plaintiff deserves to be dismissed for absence. Now, an order is passed on this application, my lady.
No. Where is order?
Order passed on this application is Annexure H. Kindly come to page 123. Per contra, the defendant bank has filed objections by mentioning that IA under consideration is not maintainable. However, the defendant bank admits the fact of possession of the document sought to be produced. It is further mentioned that it is not proper and the relevant stage to produce the document sought for, and the plaintiff bank would produce the same in due course of its evidence. As such, the IA is under consideration be dismissed. During the course of arguments on this IA, the learned counsel appearing for the parties here too have by and large repeated the above amendments of their respective pleadings. I have perused the same and also the issues framed by this court on an earlier occasion, besides provisions of procedural law contemplated under 11 Rule 14 CPC. It is needless to mention that the power of the court under Order 11 Rule 14 is discovery and to import, and an important conditions are required to be satisfied. Mainly the documents, the production of which is sought for, must be in the possession or power of the party against whom the direction is sought, and that the documents must be relied to the controversy involved in the suit, ILRs also. In the light of the above said observations in the cited cases, it is necessary to comment in respect to the pleadings as well as arguments addressed in this IA. The defendant bank is fair enough to admit that the documents sought for are very much in its possession.
No,
But
for this application,
yes,
where are their objections?
that is what I read previously. That is
Not this, sir. Not this.
Section 65 application. That is, no, they don't file any objections to that. They don't file any objections to the section 65, but they file a memo at page 139 to say it's not available, we are not able to trace it. So there is a direction from the trial court for them to produce it. On 2 occasions, their applications for adjournment is on record to say that we are looking for it, we will produce it, please give us some time. Those are annexures.
For admitting a document, what is the certificate and what is the procedure under section 65? For that, unless and until from where, from which machine, from how you have taken it and all, then no.
No, that is 65, that is 60, that I need not, because this is a document which I see, which they themselves say I have produced photocopies of. I am seeking to mark those photocopies in my evidence because I need to prove the contractual relationship between the parties in my suit as the plaintiff in that.
What are those 2 documents?
Those are the merchant agreement and the supplementary agreement, mercantile agreement.
What is their case in the written statement?
In the written statement, they admit that we have entered into an agreement. Kindly take page 46, annexure C. Kindly come to page 49. That the plaintiff was one of such merchants of the bank who was so appointed in terms and in accordance with the agreement dated 8/6/2001 executed.
This is the one you are asking.
This is the one I am asking for. The aforesaid agreement 8/6 is referred to as the agreement. Bank since then was accepting credit cards and card holders after always taking authorization. This is their document, and subsequently there is a.
What is the other document?
That is a supplementary agreement in continuation with that.
Where is that?
1 second. I think no, both are, 1 second, please.
That is para 8.
No, both are dated the same date. It is one contract, but they are named separately, but both are the same date. The aforesaid agreement is 8/6/2001. It is one.
Plaintiff was one of the such merchants of the bank.
Yes. And in accordance with the agreement.
Executed between the plaintiff and the bank.
This is the document that I.
Agreement.
Yes. This is,
Where
the-
did they, where did, consequent to the entering into the above agreement, it's.
a supplementary agreement of the same date was also executed.
Was
They
also
admit it. It may be noted that it's mandatory for the. So in order to prove my relationship, to say how these transactions happen, these documents are required. They say they have it, the trial court directs them to produce it, they don't produce it. I file an application, the learned trial court says its photocopy does not come within the definition of secondary evidence under 63 and dismiss it. My humble submission is that is an erroneous interpretation of what section 63 provides for. Any mechanical process of copying, and also subsection B of section 65 where they admit it is in their power. This application that I have filed may be kindly be permitted. I may be permitted to mark the photocopies as secondary evidence.
Agreed by the orders passed and passed on an application filed under section 65 of the Indian Evidence Act. Dated
28/10/2016.
21 or 8?
28 months.
No, if you look at the bottom at page 27, you find the date as 21, it appears. The difficulty is they don't even.
They don't number it sometimes.
They don't even, they can write the date on the top at least. 21/3 it appears. I think it's 21/3. Heard the plaintiff.
Please.
I think 21/3. 21/3/2016.
My lord, October, Melody. Because it may not, because that memo also, which is annexure M, was filed on the same day, 28/10/2016, and at annexure L.
On 21/3/2017. 21/3/2017. The plaintiff is before this court. The suit is filed seeking pass a decree for an amount of rupees 20,53,134 in favor of the plaintiff and a declaration. What is all these prayers are very.
This is from the plaint that was filed originally in Delhi.
Decree, it's a decree.
Yes, sir, suit for recovery of money along with interest, that's all.
Is not indebted to the defendant for any amount. And probably advocate appearing in the writ petitions might have drafted it. Pass a decree.
What I have noticed is in Delhi, they will ask everything under the sun and hope to get a small
So
little
they just
star.
think that it's for the court to give or not to give.
Yes.
Pass a decree of permanent and mandatory injunction against the defendant from raising any demand against the plaintiff, and also sought for the not required. It is a specific case of the plaintiff that where do you mention about all this, your agreement and all?
In the plaint.
In which paragraph?
Please, page 32.
No,
and
this
30
particular.
Agreement is at page 33. Soon thereafter, a merchant agreement was executed on or about 8th June.
It is the case with the plaintiff that he has a current account with the erstwhile ANS Grindlays Bank, and that bank merged with the defendant bank in 2000. Then in the month of September, October, the defendant appointed merchant establishments for accepting Visa and Master credit cards. And the plaintiff is appointed as a member of the merchant establishment for accepting the Visa and MasterCard credit card and other nominated agencies to his customers. And thereafter, a merchant agreement was executed on or about 8th June 2001. And the plaintiff had taken different contentions. and how he is entitled to the recovery of money. In the written statement, in the written statement, the defendant has also acknowledged the fact that the plaintiff was one of the merchants of the bank who was appointed in terms and in accordance with the agreement dated 8 June 2001, executed between the plaintiff and the bank. And the defendant has also stated about the supplement agreement that is entered on the same day, that is 8 June 2001. Thereafter, the plaintiff had filed an IA, that's IA number 1, under order 11, rule 14, seeking necessary order to the defendant bank to produce the agreement dated 8/6/2001 and supplementary agreement dated 8/6/2001. The court, by order dated 9/6/2011,
16.
9/6/2016,
Sorry, 9/6/2016.
had allowed the said application directing the bank to produce the original agreement and the original supplementary agreement by the next date of hearing. While passing such an order, the court observes that the defendant bank is fair enough to admit that the documents sought for are very much in its possession. But the defendant bank has no local standard to say as to whether this document, that the documents sought for are relevant or not at this particular stage. Thereafter, where is that they don't have the document? Where is that memo?
That is at page 139.
Thereafter, a memo is filed stating that a memo dated 28 October 2016 is filed stating that the court has directed the defendant to produce the original agreement and the original supplementary agreement, and also the supplementary agreement, both dated 8/6/2001. And they have undertaken to file. No, what is this? No, this is not the one.
Page 139.
They said they will produce it in future.
No, what they say is, well, they, by annexure J and K, they seek time to produce it. Then finally they say that the defendant bank is unable to trace these documents. That is 139. Annexure M 139. Memo, defendant of most, fourth line, it is humbly submitted that.
The same is not traceable. In future, if the documents are traced, then they will place the same before the court. At that juncture, the petitioner has come up with an application under section 65 of the Evidence Act to mark the photocopies of the mercantile agreement dated 8/6/2001, a supplementary agreement dated 8/6/2006 in the course of trial. I think there's something wrong with the
2001 only. Both are,
8/6/2001.
Both are 2001.
In the course of trial. That came to be dismissed by the court by way of this impugned order. The court observes that the proposed documents are nothing but the photocopies, and as such, the same do not fall within the purview of the definition of secondary evidence as defined under section 63 of the Indian Evidence Act. And consequently, the proposed documents cannot in the eye of law be treated as secondary evidence. In respect of the memo filed by the defendants, the documents being the photocopies, no leave can be granted and do not fall under, as it do not fall under section 63 of the Indian Evidence Act And accordingly, the court had observed that accordingly dismissed the application with an observation that plaintiff company is at liberty to pose questions upon the undisputed documents then how you will pose a document when it is not before the court?
Exactly, that. I can speak about certain terms and.
Undisputed question, documents of mercantile agreement and supplementary agreement as narrated by it in the application. Then counsel appearing for the petitioner submits that the documents are undisputed. And it is also initially accepted that those documents are in possession of the defendants. And they've also sought time to produce the documents. And later they've come up with a stand that they're not available, they're not traceable, and once they are traced, it will be placed. It is submitted that the case of the plaintiff is on those two documents are crucial for the case of the plaintiff. When plaintiff, then counsel has drawn the attention of the court to the written statement and the pleadings and the order that is passed earlier and submits that when there is no dispute about the said existence of the document, when they admit that there is that there is such an agreement, the court ought to have permitted the petitioner to mark the plaintiff to mark the document. Unless and until such document is on record, it is not possible for the plaintiff to put forth any questions to the defendant. They have drawn the attention of the court to section 63 of the Evidence Act. He submits that secondary evidence means and includes copies made from the original by mechanic process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Copies made from or compared with the original, and also relying on section 65 of the Act, section 65A(b), he submits that when the defendant who is legally bound to produce it, even after an application filed by him, even after an order is passed over by the court, has failed to produce the same. And when the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by its representatives and interest, even in that case or in this case, all those both section 60 a part of 65A and B are satisfied, and the court ought to have permitted him to mark the document as secondary evidence. The comes to 65 bottom.
Please. When the originals consist of numerous accounts, is that what my lady said?
In case A, C, and D.
Yes, in case A, C, and D, any secondary evidence of the contents of the document is available, is admissible. So this is also that, and this is a copy made from the original. They also admit. B is when existence, in case B, the written admission is admissible. So both A and B would apply because the copy is admitted. They say they have it, and I want to prove it against them. They admit it, and then there is a photocopy and
With the admission as well as he falls under both A and B.
A and B.
It is submitted that in the interest of justice, court ought to have allowed the application and the court ought not to have dismissed the application. And the reason that is stated or not, the order the order is not a well considered one. This court has permitted this court has permitted the petitioner to take out notice by way of substituted service. And accordingly, he has taken the notice and this court has held that by order dated 21/1/2025, that held that the notice to the defendant is, notice to the defendant is held sufficient. Next part. Having written and counsel for the petitioner, there is a material on record. The petitioner has sought, petitioner plaintiff has filed the suit for recovery of money based on, and is relying on a agreement dated 81/2001 and also a supplementary agreement dated
8/6/2001.
both 8/6/2001. The defendants also do not deny the same. Then on an application filed by him under order 11, rule
14.
Rule 14, that came to be allowed, and in spite of the same, the defendant, though the defendants have taken, or it was ordered, and they were directed to place the same, in spite of them, they sought for time, and finally, they filed a memo stating that it is not traceable. Then the petitioner, plaintiff had come up with these applications under section 65 of the Evidence Act to leave the secondary evidence. The court, on the ground that the court, while dismissing the application, submits that it can be what did the court says?
23. That photocopies do not answer
Last,
the.
last. Court observes that the plaintiff is at liberty to pose questions upon undisputed documents of the mercantile agreement and supplementary mechanical agreement. In the facts and circumstances of the case where these documents are admitted, and in spite of an order from the court, when the defendant is not able to produce the document, unless and until these documents are, and the plaintiff is permitted to leave the secondary evidence, which will cause loss of hardship to the plaintiff. In the particular facts and circumstances of this case, where the documents are undisputed, and even the Xerox copy is what is the copy is a?
There are photocopies. There
The
are
photocopy of the
photocopies.
same is also not disputed by the defendants. The order impugned dated so and so is satisfied. And I number
Not.
so and so is allowed, and the petitioner plaintiff is permitted to leave the secondary offense.
My lady considers some direction to dispose of the suit at an earlier date.
As this is a suit of 2005.
2000, originally 2005,
Originally 2005, renumbered
in 2012.
2012. The suit shall be disposed of within a period of 1 year from the date of from the date of receipt of the copy of the order.
I'm great.
Yes, next. Yes.
Number 30. Kevin
My lord,
Asperman,
I appear for the
petitioner.
petitioner, but my lord.
And Manjunath,
Submission, kindly pass over it, my lord.
Next 31.
Serial number 31. Keshav Bhatti A for petitioner.
Appearing for petitioner. Petitioner is the plaintiff before the trial court, my lord.
There is a counsel,
Mohammed Farooq,
no representation for the respondent, counsel for the petitioner is present. Lists this matter as part heard on Wednesday. 32.
9-1. Serial number 32. Panish Bhandari T.
For the petitioner in this matter, lordship, the suit is one for partition. The suit is one for partition, and the IA has been filed by the plaintiff for amendment of a prayer. The first amendment is with respect to the share. The share initially, which was claimed by the plaintiffs, was 1/5. Now the amendment sought is 4/5 share. The other amendment sought is that the suit filed by the plaintiff is none other than against the father. The father is a defendant number 1. So the plaintiff's contention is that the property is a joint family property and the plaintiffs have equal right in the property. Without their knowledge, the defendant number 1 has sold the property to defendant number 2 and 3. The pleadings in respect of the sale date is there in the plain during the time of filing the suit. But with respect to the prayer of not binding or cancellation was not sought for. And with respect to this prayer, the application is filed and that has been rejected by the court.
Your Lordship, the suit was filed in the year 2011, Your Lordship. The sale deed executed was way back in the year 2001. And now, after 5 years, this application has been filed after the argument, after the suit was set for this in the stage of arguments, Your Lordship. And the entire amendment will change the nature of the suit, Your Lordship. The initial suit was for partition and separate possession. Now he's asking for the declaration of for the executed sale deed that is not binding on them. And this changes the nature, Your Lordship. And previous.
But ultimately, everything, all the pleadings are on record.
Please, Your Lordship, I've also taken the contention in my written statement, and this after that which was filed in the year 2011. Though this was filed, he still did not file the application for amendment in that year. But however, in the year 2006.
Only it is like this, new facts are not pleaded. It's only the relief, the prayer is, no, for you, it's a quietus to the litigation, even for you also.
Your Lordship, how the nature, he's asked for the partition suit.
For example, she's the plaintiff.
She's a plaintiff.
No, the other defendant will file a suit stating that the child, so that sale deed is not binding on that. Then?
But however, this is hit by the
That's true,
principles that
that's
was
the
laid down.
That's technicalities. Let's look at because they are not stating any new facts.
But however, Your
And
Lordship,
now
this
it's all
was
subject to law of limitation, and the day when the amendment is allowed, from that day, it will run till such day, not from the 2011. Now they are seeking that so and so is not binding on
2016,
them.
Your Lordship.
It
This
will
was the
to the date of application. Their application for amendment is filed in the year 2016.
16, Your Lordship.
So then the limitation will be counted till that day. Whether it is such a relief is barred by limitation or not, all would be considered by the court.
Lordship,
However,
1 minute.
yes, Lordship.
Yes.
Your Lordship, however, she sought for the share of 1/4 share. But however, now after 5 years, she's taking the contention that it was an oversight and seeking a fifth share, Your Lordship. How can that be allowed when she's not even taken it?
So partition,
Please, Your Lordship.
whoever is whatever. their
Another
rights are,
one submission. There's no reasons
what will happen
assigned in
is
the
like
affidavit.
this. No. What will happen is like this. No, your sale deed is 2001.
2001.
They say their suit is
2011, Lordship.
2011.
2011. Now it's a registered sale deed. You have so many things in your defense. Then, now this 2000, another 6 years are added to that. Now they are seeking that amendment in 2016. So the limitation with regard to cancellation, it will relate back to this date, not to the date of the suit. So even on that count also, no prejudice is caused to you. And it is a full and will impose costs on them. Full and final settlement of the dispute between the parties.
My only contention.
Yes. I understand the limitations, I understand the scope and.
This court has stated, my lord, that when declaration is sought after the limitation period, my lord, it cannot be allowed. The declaration of the sale deed is dated
No,
2000.
at the stage of Order 6 Rule 17, will not decide whether all, that's what I'm saying.
I agree with the lordship, my lord.
Let the-
In that case, if this application was filed before evidence commenced, before prior commenced, then my lord, that argument is agreeable, my lord. Now, after evidence, when my lord, my specific defense is that the very sale deed is not challenged, to overcome that, this amendment is filed. Now, if this amendment is allowed, my lord, my entire case is that the very sale deed is not challenged in the beginning. That declaration was to be sought during the filing of the suit, which was even then time barred. That's another aspect. But now, my
No,
lord,
it is all the more time barred.
it's anyway time barred. Now, my lord, my specific defense in written statement and the evidence led, my lord, I say you have not challenge the sale deed, so this partition suit itself is not maintainable. That's my very stand. When that's my stand, my lord, after reading evidence, after cross, when matter is set down for argument, this is not agreeable.
Lordship, with this aspect, Lordship, the only thing I would bring to your Lordship's knowledge is that the suit being one for partition, and our contention is that it is a joint family property. When it being a joint family property, a sole person do not have any right to sell the entire property. And in a situation where the court decides it is a joint family property.
Now, first of all, what is your explanation for the delay? First, you have to answer not on the merits.
Lordship, in respect of delay, they have not mentioned any reasons as such. The only reason mentioned by the...
When you're seeking amendment after the trial, you should have said the first and the foremost is why you couldn't do it in spite of due diligence, why a particular fact is not brought to the notice of the court. That's a bare minimum.
Yes, Lordship.
This is that you have to give.
The only reason given by the plaintiff in the application is that the defendant number one being the father and mental pressure, I have not filed the prayer is that's the only reason mentioned by the plaintiff. There is no other reason mentioned
How
by the
you
plaintiff.
come over that mental pressure now?
Lordship, but the only thing I would bring this is not entirely relying upon our case, Lordship. But what this decision says is that
It's all more about indulgence of the court. You can't have a judgment in your case.
no, Lordship. What I'm trying to bring to your Lordship's knowledge is that the suit being one for partition, even without the prayer of cancellation or declaration of sale deed, that doesn't affect the suit is what this decision tells. So as how the learned counsel has pointed out that the entire suit or the defense of the defendant will entirely be
Two
set aside.
aspects about seeking a declaration that the sale deed is null and void, and the other one that it is not binding on you. That
Yes,
you need to
Lordship.
seek. You may not seek because you are not a party to that.
Not a
You may
party
not
to
seek a relief that it is not to declare it's null and void. You may not ask her, but you have to ask her that it is not binding on you. Those are two different reliefs.
Lordship, now the only prayer I could seek before your Lordship is that with respect to the share, due to typographical error, the share, because the three plaintiffs are brothers and
We
sisters.
cannot have any dispute on that, on your share.
With respect
That's
to
between
the
you and your other family.
with
members.
respect to the sale deed, Lordship, the only prayer I could seek before your Lordship is that if this application is allowed, your Lordship could give a liberty to frame a fresh issue and consider that aspect before the trial court. The only reason because that being not only a question of law and even facts and circumstance has to be seen in this said case because the pleading is not new. If your Lordship sees para number 6 of the plain, they have clearly mentioned that the father has executed such a
It
sale
is
deed.
not by way of arguments, you can't supplement all those things. What did
That's
you
the
say
only
in
prayer I could put before your Lordship because
What did you say in the IA?
no, they have
also
not mentioned
becomes
any
a-
reasons as such, Lordship. I do not want to make wrong submissions, but they have not mentioned any reasons. That's the only reason what they've mentioned. That due to mental pressure and other reasons, we couldn't seek for a prayer that's the only reason which is mentioned. But my only submission is that wouldn't change the nature of the suit because
Don't ask her.
Lordship, that is,
If it doesn't change, don't ask. So that the court will proceed with the case.
Lordship, the
As
only
far as your share is concerned,
That aspect, my lord, regardless of what is sought in the prayer, my lord, when a partition suit is decided, when a
Okay.
partition suit
No
is decided,
prejudice.
the presiding judge will definitely decide the share.
if we allow that, what will happen to you?
No, that's why I have no objection to that because they say
We'll allow,
154
we'll allow to that extent.
please.
Please come. The agreed with the order dated. Order passed in I number 12. NOS number 330 of 2011 by the so-and-so dated 4th November 2017. The plaintiff is before this court. The plaintiff had filed a suit seeking partition and to allot 1/5 share.
1/5 share.
Huh?
1/5 share.
1/5 share in the suit scheduled properties. The suit is filed in the year 2011. In the year 2018,
16 the application is.
in the year 2016, he has come up with the present IA. Where is that IA? That is in Kannada, Lordship, it's at page number, it came up with an IA
40.
stating that though in the pleadings, they have stated about the sale deed that is executed in favor of defendant number,
2 and 3, Lordship.
defendant number 2 and 3 by defendant number 1 in respect to the joint family property in the year 2001. However, they have not sought the relief that the said sale deed is not binding on them. Further, instead of mentioning that the share she is entitled to is 2 by
Now we are asking for 4 by share, Lordship.
4,
4 by 5.
4 by
4/5
5,
share.
4 by 5th share. It is stated that she sought for 1 by 5th share. As such, they have come up with an application seeking amendment. The court, by order impugned, had dismissed the said application and observed that the proposed amendment regarding cancellation of the sale deed is time barred plea. And it is settled principle of law that the time barred plea cannot be permitted to be added by way of an amendment. And relying on the judgment of this court reported in 2016 for KCCR 2955 in case of T. Gnaneshwar and others, court has held that the amendment cannot be allowed and accordingly dismissed. When counsel appearing for the petition of plaintiff submits that by way of this amendment, they're not introducing any other new facts or pleadings. In fact, though they have taken all these stated all the facts, only the relief was not sought. It is submitted that if this amendment is allowed, no prejudice would be caused to the plaintiff, to the defendants. This aspect was not considered by the court. She relied on a judgment reported in case of Vide, Sanna, Hulugappa and others. What says? Vide, Sanna, Hulugappa and others reported in ILR 1998 Karnataka 2127. Relying on this judgment, and counsel submits that the relief, whether she sought, whether it is sought, whether the relief of cancellation of the sale deed is sought or not, it will not have a binding on a suit for partition. It is also argued that even whether she has stated about sought for 1/5 share or 5 by 4,
4/5 share, Lordship.
4 by 5 share, basing on the entitlement of the parties, the court can grant such a relief. And it is submitted that without considering all these aspects, the court has dismissed the petition. Next para. When counsel appearing for the respondent, defendant number 2 and 3 submits that they have purchased a property from the defendant in the year 2001. The suit is filed in the year 2011. It is submitted that this that being a registered document as per section 3 of the Transfer of Property Act, it is very much in the constructive notice of the defendant, of the plaintiff as such, plaintiff, and it is barred by limitation. Further, without when after during the evidence and when the during the course of evidence, when they have taken a plea with regard to the maintainability of the suit, at that time, to cover up the lapses, the present application came to be filed. He submits that by way of an amendment, the time bar debts cannot be permitted. Further, he submits that after the amendment to the Order 6 Rule 17, the duty cast upon the plaintiff to say, to the party to say that in spite of due, while filing an application on Order 6, Rule 17, that in spite of due diligence, certain facts, that the facts which they sought to place before the court by way of amendment could not be brought to the notice of the court in spite of due diligence. In this case, no such amendment is made. And just like that, they have come up with this amendment. It is submitted that party cannot be permitted to amend the pleadings. He had relied on the judgment of the apex court in case of Basavaraj versus Indira and others reported in 2024-3 SEC 705. Relying on which para?
Para 12 onwards. Para 10 mil. Para 10 mil.
It's all extracts. Till para 10, para 11 and 12, relying on this, then counsel submits that the court had rightly dismissed the application and the petition is liable to be dismissed. Next para, having heard the counsels on either side, there is a material on record. The suit is filed for partition, seeking 1/5 share in the year 2011.
Lordship.
The sale deed in respect of defendant number 1 and 2, 2 and 3 is in the year 2001. All these, in spite of taking all these pleadings, they have not sought for the said relief. And after the trial has commenced or concluded,
Trial has commenced and it's come to the stage of argument.
when the case has come to the stage of arguments, at that stage, this application is filed. Whether a relief is time barred or not will not be considered by the court at the time of allowing an application under Order 6, Rule 17. While allowing an application under Order 6, Rule 17, the court has to, the consideration of the court is not on whether it is a time bar debt or not. And basically, the court has to look at the pleadings and why that, at what stage the application is filed, and whether they could make out a case for amendment of the pleadings. And once the amendment is sought, then it is for the trial court to frame an issue and to decide whether the said relief sought for is within limitation or not, which is on the merits of the matter. Coming to the facts of the case, this court has perused the IA that is filed in support of the application in Order 6, Rule 17. There is no whisper about why these pleadings were not taken at an appropriate stage. In view of the same, when the plaintiff could not make out a case for seeking the relief, seeking the amendment with regard to a declaration that the said sale deed executed by D2 and D3 in favor of D2 and D3 is not binding for a sale deed of 2001 in 2016. This court finds that the trial court had rightly dealt with the same and held that the amendment is not permissible. But when it comes to the entitlement of the share of the plaintiff is concerned, in a suit for partition, based on the pleadings of the parties, which is already put forth, if it is a share is wrongly mentioned, even if the said amendment is permitted, it would not cause any prejudice to the defendant number 2 and 3, and defendant number 1, who is not before this court.
He's expired, Lordship.
Then what
Yes.
about tellers?
We are the LRs. We are the children of defendant number 1. So it's a joint family property. Father, excluding the
And
children,
it is
have sold.
submitted that the defendant number 1 is no more, and the petitioner is the sole legal heir of defendant.
4 of them, for all the petitioners, Lordship.
Where are all the petitioners are the legal heirs in that case? the defendants cannot have any objection as far as defendants 2 and 3 cannot have any objection as far as that amendment is concerned. In view of the same, the order impugned, the writ petition is partly allowed. The amendment as far as the share of the plaintiffs with regard to 4/5.
Now 4/5 has to be.
4/5 share is concerned is allowed. With regard to the second amendment, the order of the trial court, no interference is called for.
Grateful, Lordship.
Your Lordship, kindly.
Yes.
My Lord, serial number 39, I am for the petitioner. I'm plaintiff petitioner. There's a divergent finding by the learned appellate judge. My learned friend has filed an application for early hearing. That may kindly be allowed. I have no objection insofar as that application is concerned. That application for early hearing may be allowed.
Let it be here, we will hear it. Let it be in the list, we'll hear it.
In the afternoon session, have some personal inconvenience.
This is matter on Wednesday. We'll hear it on at the request of then counsel for the respondent. IA number 1 of 2022 is ordered. Yes.
Wednesday, my Lord. Wednesday.
59 months.
If any interim order is there, extend. Why the entire afternoon you will argue that?
No, the reason being is pertaining to a land acquisition in the national highway matter, pertaining to that.
Have you informed the other side?
No,
Aliya Chandrasekhar Reddy.
Please don't make a mention without informing the other
Lord,
side.
serial number 33. My request is, Your Lordship, if it is placed on Monday, I shall argue that matter.
But you have to tell him.
I shall make, I shall.
Come at 2:30 when mention it.
My Lord,
come.
serial number 33, my Lord.
Now, in this
No,
court,
My Lord.
there is no,
No, no,
this 130 mentions.
I'm sorry.
Because some senior advocate has mentioned, I thought I'll not.
No, I understand, but 33, my lords, both of us are present, my lords. The matter is being settled. Discussions are going on, my lords. We need 2 weeks time, my lord. That is all I wanted to bring to the.
When it came before the court last?
My lords, yesterday.
Oh.
Yesterday, unfortunately, both of us were not present, my lords. Therefore, my lord, otherwise we would have made this submission yesterday.
When do you want?
My lords, 2 weeks time may be granted.
Both the parties submit that there is a likelihood of settlement. Let's just matter on 4th of March.
Highly
Only
like, my
request
lords.
is 2:30, I have a matter before court on number 2. In case if I am not present, then.
2:30 it won't reach because there are so many other matters.
Because I cannot assume and presume how the matter would go, Your Lordship. Only for that request. Request is if it is posted on Monday, I shall argue the matter, Your Lordship. I shall. Please, Your Lordship, on that threshold, at least on Monday, if it is granted, I shall argue.
I'm only telling you, you have to make a mention to the other side for seeking adjournment. I'm not, I'm not refusing
Please.
adjournment. Please understand that. Let
Please.
some colleague of yours be here.
Please, Your Lordship,
Yes.
please, please, Your Lordship. Much obliged.
Anything for signature? That let them incorporate.
Serial number 47, is it adjourned? 47.
And your sister.
That I
There are
explained.
another four
No,
people you
that is
saying.
grandchildren I explained to you, Madhavan. I
Please
explained
come.
to you.
The present CA number 295 of 2023 is filed in COP number 112 of 1994, where a direction is sought to the official liquidator to execute the sale deed in favor of applicant number 1 in line with order dated 16th July 2004, passed in company application, in batch of company applications. This court the company court in a batch of company applications has passed an order on 16th July 2004. That it will be in the interest of the creditors and other stakeholders to permit the official liquidator to effect sale of the houses in occupation of each of the occupant on accepting the price of rupees 12,500 as has been offered by each of the occupant. The official liquidator, on receiving the full sale consideration, is directed to execute the necessary sale document in favor of the applicants as per law. And it's also made clear that the expenses to be incurred towards stamp duty, registration charges, and other incident charges are all to be borne by the purchasers. And the applicant purchasers are given 3 months' time for paying the sale consideration and to have the sale deeds registered in their favor. It is also made clear in the order that the order will hold good in respect of all occupants in occupation of the 300 houses, and no separate order is required for the official liquidator to execute a sale deed in respect of the 300 houses in occupation of the occupants. It is the case of the petitioner that the father of the petitioners was allotted quarter bearing number 131B, situated in MNPM Housing Colony, Belagula, Srirangapatna Taluk, Mandya district. The father was working as a machine boy for the paper machine department. And the allotment was by order dated 17/5/1988. The father of the petitioners died on 16th December 2019. During his lifetime, he filed CA number
841 of.
CA number 841 of NC Chakravarti. He is your father.
Yes, ma'am. 841 of.
Filed 841 of 2011. And the court, along with other applications, by order dated 9th March 2012, had disposed of the applications, observing that at this juncture, the positive direction to execute the sale deed cannot be issued to official liquidator as things stand. However, liberty is granted to the applicant to seek establish the fact establish the fact that they were not only the employees of the company in liquidation, but also the residents of the quarters. And once that is established, the official liquidator shall act in accordance with the directions issued by this court by the court dated 16/7/2004 in CA number 12 of 2002 in the connected batch. It is the case of the applicants that after the death, in spite of the father of the applicant, the father of the applicants having paid the amounts in the year 2000,
2004, my lord.
2004 itself, so far, the registration is not done. Next one. It is submitted on behalf of the official liquidator that as all the documents which are required were not before them, they would not register the document. It is submitted that now along with the writ petition, he has filed the two basic documents, that is the allotment of the father, Aadhaar card,
Yes, other.
and the family certificate and the death certificate. It is submitted that the father is succeeded by, is survived by the petitioners. As per that, the daughter is a second applicant or the first applicant.
Second applicant.
Second applicant has no objection to execute the sale deed in favor of the first applicant. It is submitted that once the draft sale deed is furnished, along with the indemnity bond and other particular an indemnity bond, once the requisite documents are furnished, within 1 week from there will not be any difficulty for the official liquidator to execute the sale deed. It is also submitted that no doubt the amount is paid in the year 2012. Until now, the sale deed could not be executed. In the light of the submission of the made on behalf of the official liquidator, there is no dispute about the fact that the father of the applicant was allotted a quarter.
Yes, yes, ma'am.
Was
Quarters.
allotted a quarter, while the allotment dated 17/5/1988, and he has been residing in the same till he died in the year 2019. They've also placed those documents before the court. And as far as that is concerned, the official liquidator has no objection. Then coming to the execution of the sale deed in favor of the first applicant is concerned, as submitted by the official liquidator, there needs to be the bond as required and any undertaking to be submitted by the second applicant before the registering authority. In that view of the matter, this application is disposed of in the following manner. Number one, the applicant shall place the draft sale deed and shall furnish the draft sale deed and other documents to the official liquidator within 1 week. Is it okay or some
Yes.
more time?
No problem. We'll
Within
submit.
1 week from the date of receipt of
set
the
up.
copy of the order to the official liquidator. Within 10 days from thereon, the official liquidator shall execute the sale deed accordingly. Application is disposed of.
What's over?
23, aforesaid for petitioner, K.V. Narasimhan for respondent.
20? Hmm.
I appear for the petitioners in this matter.
Hmm.
With respect to IA, my lords, the petition came to be dismissed for non-prosecution on 9/8/2024. My lord. The reason is, my lords, I was held up in another court. So by the time we reached
And
this,
there is no delay in filing it.
no, my lords, immediately I have filed the recall.
Argue the main matter.
Sure, sure.
Yes.
I'm ready. Petitioners, my lords, petitioners are the defendants.
You're
before-
ready?
I'm ready.
Petitioners are the defendants before the trial court, my lords.
Hmm.
The respondents will file a suit seeking quashing of the seeking declaration to declare the GPA executed by the respondent's father and the gift deed executed by defendant number 1 in favor of defendant number 2 to be null and void. My lords, the facts of the matter, my lords.
Like this, you are the defendant in the suit.
Sure, sure.
Plaintiff filed the suit for declaration that the
Declaration.
sale deed executed by
Say not gift deed, my lords. One GPA executed by their father, Pillappa.
is arrayed as
He is not, he is no more, my lords. Pillappa is not a. Is null and
executed the GPA in favor of which defendant?
first defendant.
And first defendant in turn has executed a gift
Gift deed in favor of second defendant.
You are?
I'm for the both the defendants, my lords.
Oh.
That is their prayer, my lords. And the second prayer is, my lords, for permanent injunction with respect to B schedule prop.
Declaration that it is null and void.
Null and
Oh.
not
Then
binding. Now, my lords, the case is, my lords, Pillappa, he was the owner of survey number 20 to an ex.
Tell the court what has happened. What is IA?
IA is, my lords, it's for amendment. At the flag end of the case, my lords, the pleadings are completed, issues are raised, both the side evidences are completed, cross-examination is done. After the arguments, my lords, they come up with an IA seeking an amendment with two prayers. Declare that the A schedule property absolutely belongs to the plaintiffs. One, first prayer. Second prayer is, my lords, if the trial court comes to the conclusion that the plaintiff is not in possession of the property, to give them possession.
I think this is one trend in Karnataka.
Yes, my lord.
Why should the court come to?
Yes, my lord. That was,
For him to say, but those are two different pleadings, sir.
please, my lords.
Either you should be in position or you're not in
Not,
position.
not in possession.
Why should the court say that you are not in position, so we'll grant recovery?
That is that. My lords, in one stretch, my lords,
Please,
Now, if you are in possession of the property, question of recovery will not arise.
please.
So either that is wrong or this is wrong.
My lord, what has happened, my lord? We state that, my lord, we were the owners of the suit property. And when the defendants, my lord, approach us, we were working under the defendant because defendant was a builder, my lord.
Yes.
So when we had a property in the eastern portion of schedule number A, that is a small shed, my lord.
Hmm.
Defendant number 1, my lord, asks us that we'll be keeping some construction material in your shed. So he'll ask us permission, we let him include all the materials. This is our case, my lord. This being the case, my lord, they take up the contention that we have executed, not my father, my lord, plaintiffs has executed a GPA in their favor. And subsequently, defendant number 1 has executed a gift deed in favor of defendant number 2. As my friend said, my lord, we filed a suit seeking for cancellation and injunction. My lord, now at the time of arguments, my lord, we have not sought any change, my lord, any amendment with respect to pleadings or with respect to evidence, my lord. Only with respect to prayer portion, my lord. We have sought for an additional prayer seeking.
But that is runs contrary to your pleadings. When you yourself are saying that you are in possession of the property, where is the question of recovery of possession?
My lord, we have
Your
stated,
prayer
please.
should be in consonance with your pleadings.
Please, my lord, with respect to the amendment of pleading, amendment of the plaint, we have sought only for declaration, my lord, and possession. My lord, my lord, my humble submission is, my lord, it is not changing the nature of the claim which we originally made.
Originally, what you sought, declaration, injunction,
Yes,
not
Declaration.
recovery of possession.
Please,
It will change.
if
but the
possession,
nature of my, we are,
No, not
please.
that. You say that you are the owner of the property.
please,
But for so and so reason, your father has executed a GPA in favor of D1.
not my father, ma'am. I have executed it.
Now you have
That is my-
executed in favor of D1.
That is their case.
D1. D1 in turn to D2.
Please,
That's the case.
that is their case.
Our case is that,
Dependence.
yes, ma'am.
Hmm.
Our case is that we had given them permission to store the construction material in our shed.
No, but the documents, whoever has executed have executed. You also can't have a different story.
No, my lord, our story is different, my lord. That is an unregistered GPA. That has not been mentioned. That is an gifted is also.
It's a registered GA.
registered.
Registered document.
Please, madam, my lord, we get to know only in the year 2007.
Whatever it is,
Yes.
right or wrong, there are
Please.
two documents.
Please,
One is an unregistered GPA, other is a registered gift deed.
Please.
Now you say you are in possession of the property.
Please.
That gift deed and the GPA are not binding on you.
Please.
So how come this, and you sought for permanent injunction,
Please.
assuming that you are in possession and they should not, how this recovery of possession will come?
my lord, there are judgments, my lord, which state you can claim contrary reliefs. So if at all I fail in my attempt to prove to the court that I'll not be able to prove my declaration or title, the court can very well grant me the limited period to the extent of permanent injunction. My lord, to take a contrary reliefs, my lord, there are judgments, my lord, stating that the plaint can be filed seeking for contrary claims. So that will be my submission, my lord. And my lord, with respect to submission made, my lord, there are judgments, my lord, where initially I claim for one prayer. At the fag end of the case, if I seek for multiple reliefs without changing my pleadings, without changing the nature of the suit, my lord, the Supreme Court, my lord, has allowed the amendment.
Is it not a how is it, how do you say that it is permissible?
My lord, all please.
Let's see.
Yes, please.
No, the evidence is let in.
Please.
And
It's
basing
posted
on,
to arguments.
basing on the fact that you are in possession of the property.
Please, my lords.
My lord,
You have let in evidence saying that you are in possession of the property.
please. My lord.
And basing on your pleadings, issues are framed.
My lord, because they have also led, my lord, evidence stating that
No,
they are.
the
Please,
issues are framed basing on the pleadings.
please,
Basing on the issues, evidence is let in.
please,
Basing on that, now the judgment will be pronounced.
please.
Now, how can at this point of time, how you will be permitted to take this kind of inconsistent pleas?
But only with respect to prayer, my lord. We'll be praying we'll be seeking for our relief, my lord, only based on already the evidence which has been led and the arguments which are being.
Yes,
Please, my lord.
yes. And what is the reason for seeking this amendment after the trial? What is the reason stated in support of the
Lord,
idea?
if my lords may come to page number 29, man.
Yes. Yes.
Page 30, para 3, my lord. You have sought the relief of declaration in relation to alleged.
It is 20, after 27, it is 30 page number.
27, 30 is the affidavit with respect to Order 6, Rule 17 application. We've explained the reason in that. We have sought the relief of declaration in relation to alleged general power of attorney, gift deed, etc. The defendants are contending that they are in possession and enjoyment of the B schedule property. Myself and first
First
plaintiff.
step is for filing this application at that stage, that's the first step to answer.
Please.
That is not answered in this petition.
Because, my lord, they have led evidence stating that they are in possession. That is the reason.
No, it's not about leading evidence. They have stated so. That is a specific case, even in
Yes,
the written
please.
statement. They have not stated some new things or some has come to light and the stage of evidence. Please tell this judgment, we will pass orders. For what purpose?
My lord, with respect to the submission made, my lord, that contrary claims can be made.
Mm.
When lords may take it up tomorrow, my lord, I'll bring the judgment so that it can be decided.
Not tomorrow.
Please.
We'll have it on Thursday. This is matter on Thursday. On that day,
Please.
we'll recall that order also.
Please.
At the request of the counsel respondent. Yes.
Great.
Please, ma'am.
Seal number 30. Devi Narasimhan, petitioner.
In this matter, I appear for the petitioner.
Then Manjunath.
Lord, this is a matter, my lord, with respect to
B.
return of plaint, my lord. I appear for the plaintiff, my lord. My lord, initially, my lord, in the year 1997, we file a suit, my lord, for declaration and injunction. My lord, that suit came to be returned under Order 7, Rule 10, stating that the court in which we presented our plaint doesn't have the jurisdiction to decide, my lord. Subsequently, my lord, in the jurisdictional court, we file a fresh suit. Then, my lord, the records of the old suit came to be transferred to the jurisdictional court. We file a memo stating that we'll be withdrawing our new suit because the old suit has come. I may explain it again, my lord, with the numbers.
No. You filed a suit.
Please.
Record
Please.
on the ground that the court had no jurisdiction. You then presented it before the other court.
Please.
Uh,
Then, my lord, the records of the old suit, my lord, is transferred to the jurisdictional court by the old court. My lord. That is civil judge to the senior civil judge. Then, my lord, we file a memo stating that we want to withdraw the new suit because the old suit has come to the jurisdictional court. Then, my lord, our new suit, that is 57 of 2007, is withdrawn. The old suit number is 465 or 1997. Then, my lord, what happens? The records of the original suit, that is 465 or 1997, is clubbed and sent to the central record room with the new suit, that is 57 of 2007. My lord. So what happens, my lord? We subsequently file a memo stating that to dealing both the cases and allow me to continue with the original suit which was filed, that is 465 or 1997. This application, my lord, came to be allowed by the trial court. And, my lord, subsequently, I was given a new number, that is OS number 40 of 2014. I lead my evidence, my lord, PW1 evidence is done. Now, my lord, the defendants challenged that order of delinking before the High Court, my lord, in GMCPC. High Court, my lord, holds that you could not have filed an application in the new suit, whereas they'll give me the remedy to go and approach the trial court and file an application stating that allow me to continue the suit. And they set aside the order of the trial court where they dealing both the suits and allowed me to continue. This, my lord, was decided in the impugned order. The trial court states you could not have filed an application in the new suit which was already withdrawn. So you should have filed an application, and they closed the suit. Now I have no remedy. This is my problem. Now I am left with no remedy, my lord. The entire proceedings are closed.
How complicated the whole issue?
Please, my
has
lord.
been.
My lord, the only reason, my lord, with respect to the entire dates and my lord, the delay was not caused on my part, my lord. Initially, my lord, in the year 90.
Come to the impugned order.
Please.
Where is impugned order?
My lord, it's at page 107, my lord. 114. Annexure came.
Read from the beginning.
The plaintiff had filed one suit, OS 465 bar 1997, and court held that it has no jurisdiction to entertain the suit and directed the plaintiff to present suit before jurisdictional.
First of all, I'm not able to understand what is this. When the court returns the plaint,
Please, ma'am.
you will take it to the next court where the court has jurisdiction and you will present the
Please,
plaint.
My lord, the problem what happened, my lord, when the court returns the plaint, it should give an endorsement and it should intimate the same to the plaintiff under Order 7 Rule 10A, and plaintiff should make an application and court should direct both the plaintiff and defendants to approach the jurisdictional court and also set a date, my lord.
That's what must have been done in.
That is not done, my lord. That is my
Not
grievance.
then you should ask the court to do it.
That is not done, my
Even
lord.
doing it, having filed already a plaint.
Please.
And there is a direction to present it before the appropriate court.
Please, ma'am.
You just let that go and file another suit.
My lord, what happens, my lord, here that entire endorsement.
That's where the whole litigation is started by you.
Yes, ma'am. Not me, my lord. The trial court did not give me directions to approach which court.
But then, you're not remediless, sir.
My lord, the date and the court to which I should have gone.
That can be always sought for.
Please, my lord. That has not been done by the plaintiff.
Then you file another suit and this will come, that will be.
Then I subsequently.
Yeah, let's go further.
Please, ma'am.
File another suit, that is 57 of 2007.
2007, my lord. And my lord, as I stated, my lord, he files a memo and gets the matter as not pressed. It is not dismissed, my lord, it is not pressed. on 1/9/2007, my lord.
So OS number 57 of 2007
Please,
is the second suit filed by you.
yes, my lord, in the jurisdictional court.
And once this is transferred to that court,
Please,
you sought dismissal of this.
yes, ma'am.
You want to withdraw this.
Withdraw, ma'am,
Hmm.
as not pressed.
Dismiss.
Please,
That's on 1/9/2007 as
Please,
not
ma'am.
pressed.
1/9/2007 as not pressed, my lord. That was permitted by the trial court. My lord.
What is this D-link?
My lord, what happens when the matter is dismissed? When the records of the original suit, that is 465 of 1997, comes to the jurisdictional court, the entire records, my lord, were clubbed with my new suit.
So no, both new and the old are together.
They were in the central record room, my lord.
Hmm.
Because the new suit is not pressed, it is taken off the record.
Then that order has attained finality.
That order has attained finality.
Then
We don't have any grievance with respect to that. Then, my lord, I file a memo, my lord.
where is the order of the High Court?
My lord, it's at page 107, my lord. Annexure J.
What is the difficulty of the defendant? What is the difficulty of the
But
defendant in that delinking?
My lord, so far as delinking is concerned, my lord,
You have questioned it.
yeah, I have questioned it, my lord. The High Court has answered it.
Let us see where is that it is answered.
Yes, my lord. Page number, it starts from page number 107, Annexure J. May I read, my lord? Paragraph number 3. Learned counsel for the petitioner made the submission that the respondent number one plaintiff earlier filed the suit in OS number so and so. The suit was filed. The court passed the order that court is not having pecuniary jurisdiction to entertain the suit and directed the plaintiff to present the suit before the court having jurisdiction. Subsequently, the plaintiff filed another suit in OS number 57/7. Thereafterwards, by placing a memo.
What kind of unnecessary?
My lord, I don't know, my lord. From 1987, my lord, several cases have been filed. Not only one case, my lord,
My lord.
several cases have been filed. My lord,
This is one classic case.
Yes,
My
where
lord, my
people,
sub, please, I'll,
No, even for the defendant also, there is no reason
Please.
to come to the High Court.
my lord,
Please,
my
my
lord, I came to High Court, my lord. High Court has, my lord, given a direction stating that they have to make an application before the appropriate, before the jurisdictional court. My lord, by pleading all these things, my lord. My lord, they have, once the plaintiff is returned, my lord, they ought to have filed the.
No, anyhow,
Yes.
you wanted to withdraw that petition. That petition, that the suit is withdrawn, dismissed as withdrawn. And you didn't question that.
My lord, I didn't,
You
yes,
didn't question it.
because.
So the first suit, what is there, is there. No, this, just for that purpose of delinking, you come to the High Court. And what is the purpose to be achieved by all this? Let it continue. He can't be remediless.
Lord, he can't be remedialist, my lord. Once the plaintiff is returned, my lord, he has to present it within the time bound, my lord. My lord, he has not done it. My lord, rather, my lord, filing the, my lord, presenting the plaint, my lord, within a time bound, my lord, he filed a second suit. My lord,
The court has permitted him to withdraw the second suit.
second suit.
No, because he has not represented it within the time.
Court said, you go and make an application before the court, respective court, and narrate the facts, and so that court can give a finding whether, my lord,
The order is passed when,
my lord,
that's on 1st March 2016,
yes,
arising out of a writ petition of 2014.
yes.
1st March 2016. Then
Yes.
what did you do after that?
My lord, the plaintiff has to say, my lord, because
What have you done after that?
then trial court considers this, my lord.
When did you file the application?
no, he
No,
has
but
not
that is a
filed
formal application, my lord.
That's what.
Please, ma'am.
Not that you sit at your home and the court will look at it.
Please, ma'am.
When the court has specifically observed the High
Please.
Court, go before the court and
Please.
bring all the facts.
Please.
Then what did you do?
He didn't do anything.
No, I fairly, I should concede, my lord, we have not filed an application.
Anything.
But my submission, my lord, that is a formal application, my lord, from 1997 till today, my lord, I have not been able to contest the matter on merits, my lord. Lord, as my lords rightly pointed out, when we are ready to go ahead with the old suit,
No.
there was no reason for them to
We
file an
have a
application.
Procedural law.
Please, ma'am.
We are bound by law.
Please, ma'am.
When something is, when the CPC says how it has to be proceeded,
Please,
you have to do it that way.
please, ma'am.
If you don't do it, then you have to face the consequences of
My
it.
lord, with respect to that, my lord, if my lords may give me liberty, my lord, So we'll be
What is the
filing it.
relief you sought? What is the relief you are seeking in the suit?
It's a suit for declaration and injunction.
No, only injunction.
No, declaration is there. Declaration is there.
Declaration that?
Like I am the owner of the suit property. Lord, I've not been able to contest the matter on merits, my lord. My lords may
Yes,
kindly
Mr.
consider.
Counsel.
My lord, kindly appreciate, my lord, this, since 97, my lord, he has filed a defective suit. In the year 2007, 2006,
97, he has filed the defective suit.
defective suit.
Before a court.
Before
It was returned.
6,
25/9/2006, my lord. to be
25/9/2006, my lord.
Filed when?
My lord, on the particular,
Not date,
1997,
which year?
97,
1997.
yes,
When the plaint was returned,
25/9/2006.
what was happening till such time?
My lord, just the proceedings, my lord, the no progress, my lord.
And then 2006.
Yes, my lord. And thereafter, my lord, the plaint was returned. And they filed, my lord, rather making a request to the court.
2006 or when suit is filed?
In the year, my lord, 2/1/2007, within a period of 2 months, I filed. My lord.
They filed a fresh suit on 1/1/2007. After almost 3 months thereafter, my lord, he filed a suit. My lord, again, that.
And you also don't dispute the fact that in the order, when the plaint is returned, like so-and-so date or where it is to be, nothing has been prescribed in the order.
No, my lord, I concede that. Lord, so far as, but, my lord, they have to have
He
made
thought that it is returned, he will take it and do it something, so he did it. Now, when it is returned, he thought he will take it home and present it whenever he wants, so he presented it.
He presented a new case, my lord, with the same cause of action. My lord, the suit is for only bare injunction, my lord. My lord, apart from that, he has also filed one more suit against me. My lord, for seeking for cancellation of the compromise decree which I have entered with respect to the suitable property and declaring that he is the owner. My lord, that suit got dismissed. Thereafter, he filed.
That is which year?
My lord, 2000.
After that, no, 1997, suit is the first suit.
Yeah, no, 97 is the first suit. Second suit is 764/2000. My lord, after full-fledged trial, my lord, the trial court dismissed the suit in the year 2018. And RA is filed. RA is also dismissed. My lord, like this, my lord, several cases have been filed. Unnecessary.
Respect to the very same schedule.
Very same property, very same property.
Let's see the suit,
Yes, ma'am.
which you are referring to the year 2001 or 2000.
2000.
Where is that you have it?
My lord, I have a copy of it.
Please
With
pass on.
respect to that, I don't have any instructions, my lord. With respect to that suit,
Get instructions.
please.
Heard both the counsels in part. This is on Thursday
Grateful.
as partner. By the time you get all instructions about this litigation.
Please, man, I'll take the number. Suit.
Number 36. Yes, Balgangadhar for petitioner. Ravi HK for respondent.
This is with regard to the earlier occasion, your lordship heard me. Granting police protection suo motu ex parte in execution proceedings. Then, my lord, I approached this honorable court. Stay order is granted in my favor. Stay order is there, my lord. I don't know, since because of my only grievance is, my lord, I may be guilty. If I am guilty, my lord, honorable court is having a very power to punish me. But suo motu, my lord, could not be granted.
Tuesday, no representation for the respondent. Counsel the petition is present. This is matter as partner.
Please.
Is
My lord,
27?
date.
Tuesday.
Please.
28.
37.
Number 37.
Go for the respondent.
Markey.
Respondent.
No representation for the petitioner. Counsel the respondent is present. This is matter. Any interim order in this?
No, my lord, no.
Interim order.
It's a
This is
suit
matter
for-
on 18th of March.
The suit for injunction, temporary injunction application was allowed and MA was dismissed. Challenging those two orders, my lord.
So no, no order in his favor.
Please.
Number 38. P.N. Nanja Reddy for petitioner,
37.
Hmm?
37.
18.
Yes.
Yes.
Cell number 38, P.N. Nanja Reddy,
When is the suit?
Kartikeyan.
Suit is of which year?
Suit is 2018, madam.
2018.
37.
37.
He was not there, no, he has come.
Yes. Suit of the year 2018, madam. Suit is for permanent injunction, madam. This is the definite writ petition. Then, madam, it is a concurrent finding. Madam, the respondent here in the plaintiff has filed a suit for permanent injunction. In that suit, he has filed an application seeking interim injunction. That came to be allowed. Challenging that, madam, we have filed the miscellaneous appeal that has been dismissed.
Let's see the order in the MA.
In MA, madam.
No interim order in this.
No. No.
What is the state of the suit now?
Now it is in evidence stage, madam.
It's posted on 17/2, madam.
When is the order in the MA?
MA order is, madam, 11th December 2018. Yes, ma'am.
But I'm in a
So
position
for
of.
the last how
property.
many years?
6
7 years, no injunction.
Yes, madam.
So let the court proceed with the matter.
Interim injunction has been granted in favor of the plaintiff.
It is granted, it is, that order is set aside in the MA.
No,
No,
that
madam.
has been confirmed.
Injunction was allowed.
Defendant-
and the MA filed by the petitioner herein was dismissed.
Defendant has challenged.
Injunction is confirmed.
Yes,
Defendants,
defendant has challenged, that has been dismissed, madam. Then we have filed the writ petition.
even that way also,
Yes, ma'am.
let the suit itself be disposed of.
As early as possible. Already it's 2018 matter. ma'am.
And then it's posted
Where
for
suit
evidence.
injunction?
Hello?
It's a suit for injunction, where
For bare injunction.
Bare injunction.
the agreed with orders passed in MA number 23 of 2018, dated 11 December 2018. The defendant is before this court. The respondent hearing had filed a suit. The respondent plaintiff had filed a suit. Case number 454 of 2018, seeking permanent injunction. In that he has filed an IA seeking interim injunction, which came to be allowed by order dated
13th November 2018. ma'am.
13th November 2018, aggrieved thereby, defendant had carried this matter in MA number 23 of 2018. That came to be dismissed by order dated 11 December 2018. Against that, the present writ petition is filed. This writ petition is of the year 2019. There are no interim orders in this writ petition. Then counsels appearing for both the parties submit that already. The suit is at the stage of evidence.
Evidence.
Stage of
posted on-
evidence. Huh?
It's posted on 17/2, madam.
And the matter is coming up on, is posted to 17/2/2025. The plaintiff is enjoying the injunction right from the year 2018. And considering the fact that there are no interim orders in this petition, which is of the year 2019, without going into the merits of the matter, this court deems it appropriate to dispose of this writ petition, directing the trial court to dispose of the main suit as expeditiously as possible.
Time limit may fix, ma'am, because madam, actually we are in the post. Sorry, madam.
1 year.
Much obliged.
Cell number 38, P.N. Nanja Reddy for petitioner, Kartikeyan for respondent.
Interim order is there. Look at it, fine, Anita.
No, I missed.
No representative on behalf of both the parties. This is marked on 18th of March. Don't extend interim order.
Cell number 39, 39 adjourned, 40 adjourned, cell number 41. Cell number 41, Raghavendra K
Petitioner.
for petitioner,
The
Have an interim order. in your
plaintiffs.
case.
No.
Have an interim order in your
Yeah,
case.
is there. Interim order is there.
Who appears for the respondent?
There are.
the petition.
Both are.
So. Yes.
Plaintiff's writ petition. Plaintiff, this petitioner filed a suit for permanent injunction against the respondent. The father of the petitioner and the respondent executed an agreement saying that
Father of the
father of the petitioner, between the father of the petitioner and respondent.
respondent is the defendant.
Yes, defendant.
Hmm.
There was an agreement in the year 1987. The agreement, the results of the agreement is that the father of the petitioner has to give up 1 acre of land to the panchayat for development of the sites for poor people. And in turn, the panchayat has compensated to the father of the petitioner a site that measures 110 feet by 250 feet. That has been executed. I have given up the 1 acre of land. They have given me that site. In that site, since 1987, I am in the possession. I have tied the cattle and I am utilizing the said property for my agricultural purpose.
All this transaction has taken place. In
Yes.
what manner?
That one Muchalke Patra, that is undertaking.
With an undertaking?
Yes.
You have given 1 acre to the
Yes.
to the panchayat.
Yes, they have given
That has
site.
given you one
Yes, that is the only document. Yes.
all by way of one
Yes.
letter between both of you.
Yes.
Then what suit you have filed?
Permanent injunction
Hmm.
against that defendant, Panchayat.
Panchayat. What happened to that?
Because I have approached the Taluk Panchayat EO to mutate after death of my father. I have approached the EO, Taluk Panchayat, to mutate my name in the revenue records, in Panchayat records. For that, they have also issued. But the Panchayat PDO, they have disturbed me. When I have put up, started to put up construction in that site, they have troubled me.
Because the property stands in their name. Property stands in the name
Yes,
of the
yes.
panchayat.
But they have categorically admitted in the written statement that I have
No,
given
but
up 1 acre of land.
Oh, the rights in the property will transfer.
Definitely, it must be registered. Must be registered. For the purpose of evidence only, I have produced this document.
What is the document?
That Muchalki, Exhibit P7.
Which is unregistered, unstamped document.
Yes.
And for
It
the
is
purpose
stamped, but unregistered.
registered document, you
Yes.
wanted to rely for the purpose that,
Yes.
by virtue of that document, your father has become the owner of the property.
Yes.
Then the court had dismissed it.
No. Initially, this Muchalke Patra, that what is the agreement between the both the parties, that has not been admitted in the evidence. I have approached this honorable court against that order. This honorable court said that you have to admit this document only for the purpose of looking into the evidence, whether he is in the possession or not.
Collateral purpose.
A collateral purpose. Allowed the writ petition. Kindly see the judgment passed by this honorable court.
Take that.
This document has been marked. Now I am before this honorable court. My grievance is that in that document there are 2 witnesses there. They have not led the evidence. I have not brought them to lead the evidence.
The plaintiff has not relied on this as a document of title.
As a title, yes. That observation has been made by this honorable court.
But you are relying on that.
I have no other alternative.
No. See, the court records that
This is the finding of the court while allowing the writ petition.
has not relied on
Yes,
the
yes.
so-and-so Muchalika so-and-so as a document of title,
Yes,
under which he is claiming title, but precisely that is your case.
yes.
Uh,
The person who have signed as a witness in this document, I have to bring them before before the trial court to lead the.
It is like this. The panchayat is the owner of the property.
Yes,
First of all, there cannot be injunction against the true owner,
yes.
isn't it? And the document is a sole basis for you to say you are the owner of the property.
That finding has
Come
to,
to the impugned order.
impugned order is at page number 82, my lord.
Yes.
The plaintiff has filed this application under order 18 rule 17, read with section 151 of CPC, order 16 rule 1 and 2, read with section 151 of CPC and section 151 of CPC to permit them to lead further evidence on behalf of the plaintiff and also to examine their witness. The PA holder of plaintiff has sworn to the affidavit wherein he has stated that only previous date of hearing the case was posted for further evidence, but the witnesses who were intending to give evidence on his side were suffering from ill health, and for that reason he could not able to file witness list and to examine them, and for that reason further evidence was taken as nil and case was posted for arguments. Further, the said witnesses are very essential to prove his title and possession and also the execution of document dated 25 to 19, this is 1987. On the other hand, the defendant has filed 3 objections in the common form, submitting that the case is posted for arguments on merits and also the defendants have not adduced any evidence. Hence, the application does not survive for consideration. The suit is one for permanent injunction wherein POA, power of attorney holder of the plaintiff was examined as PW2 and through him, exhibit P1 to P13 has already been marked, and earlier through PW2, exhibit P1 to 5 was marked and accordingly he was cross-examined and later as per application of plaintiff case was again recalled and he had filed further documents which were marked as exhibit P6 and P7. P7 is, this is the document. Again, his evidence was recalled on 31/1/2019 and exhibit P8 to P13 were marked, and after that he was fully cross-examined and accordingly case was posted for further evidence on behalf of the plaintiffs. But however, in spite of marking, the plaintiff has not filed witness list, and for that reason further evidence was taken as nil and case posted for defense evidence. But however, in spite of our advancing argument, now the plaintiff has filed the present application and reason stated that in the affidavit is that witness proposed to be examined by the plaintiff was suffering from ill health, and of course it is a valid reason. The trial court come to conclusion that the valid reason is valid. Not examine the said witness on the date fixed for evidence, but further in this case it is to be noted that the ill health of witness was no impediment for the plaintiff to file witness list, and that reason assigned by the plaintiff for not filing witness list appears to be imprudent, and for that reason the application deserves to be dismissed. The trial court accepted my reason as genuine, but I have not filed the list of witnesses. That is the only discrepancy on behalf of the plaintiff. How can the witnesses are not feeling well? How can I approach them to come to the court? Therefore, I have kept it. After that, I have filed the application. That application has been dismissed. This is the only crux of the matter. If the application is allowed, I will put him in the box and they will cross-examine. Then ends the matter. That's all.
2013 suit.
Yes.
No reason. Please come. Agreed with the orders passed on an application. Under order 18 rule 17, section 151 CPC. 16 rule 1 and 2, read in 151 CPC to permit the petitioner to lead further evidence was dismissed against the plaintiff is before this court. It is the case that the power of attorney holder of the plaintiff has sworn to an affidavit wherein he has stated that on previous date of hearing, the case was posted for further evidence. But the witnesses who were intending to give evidence on his side were suffering from ill health, and for that reason he could not able to file witness list and examine them. For that reason, further evidence was taken in and the case was posted for the arguments. And as their evidence is very much crucial for his case. And with regard to the execution of the document dated 25 to 1991, he has come up with the present application. The court by order impugned had dismissed the petition. And while dismissing the petition, it is observed that The suit is for one for permanent injunction. That the power of attorney holder was examined as PW2 and through him exhibit P1 to P13 are already been marked. And through PW2, exhibit P1 to 5 were marked. And it was cross-examined. Yes, the later further documents were filed, were marked as exhibit P6 and 7. Again, his evidence was recalled on 31/1/2019, and exhibit P8 to 13 were marked. And after that, he is fully cross-examined. And case was posted for further evidence on behalf of plaintiffs. But however, in spite of marking the plaintiff has not filed witness list, and for that reason, further evidence was taken as well. And case was posted for defense evidence. After advancing the arguments, the plaintiffs have filed the present application. That the witness, due to ill health of the witness, he could not file the list of witnesses. Court observed that the ill health of the witness was no impediment for the plaintiff to file witness list. And the reason assigned by the plaintiff for not filing the list appears to be not proven and accordingly dismissed. And by imposing cost of ₹300. When counsel appearing for the petition submits that the court has observed that the witness is unwell, and for that reason he could not file the list of witnesses. That the court ought to have considered as examining them is crucial for the case. And ought to have allowed the application. He submits that the reasons that are assigned by the court in dismissing the application are not the valid reasons. No notice is served on the respondents. No wakalat is filed on their behalf. Next, having heard the learned counsel for the petitioner, there is a material non-record. This is a suit of 2013 where the petitioner is seeking injunction. Once after the cross-examination, of the plaintiff, again on his application he was recalled, and later another documents were filed. Still, the court has accommodated them, and he has not failed to furnish the list of witnesses. Then after that, he has advanced arguments. Thereafter, this application is filed. Court has rightly observed that if the witness is unwell, that cannot be a reason for the plaintiff, or that can be an impediment for the plaintiff not to file the list of the witnesses. As rightly observed by the court, there are no bona fides in the manner in which the plaintiff is prosecuting the matter. The court had rightly dismissed it. Court finds no reasons to accordingly dismissed.
I have not advanced the argument.
It is recorded in the.
No, here, in spite of advancing argument, I have filed the application. I have not addressed the argument. I have not started it.
Number 42 urgent, 43 Sachin BS for petitioner.
I appear for the petition, but if my lords remember, this matter pertains to my lords my cross-examination through VC.
You said you wanted to get in.
Please, my lords, the information is that there have been instances, my lords, where the trial court has allowed my lords cross-examination because of having
allowed, you go, but this
lords,
court will not
it may be reconsidered, my lords, in respect of 2020 circular of this Honorable High Court. Lords, that may be reconsidered, my
I
lords.
cannot pass such an order because I have already taken a different view on this. Or if you want, I can adjourn the matter.
Lords, it may be just reconsidered, my lords, because the reason that is given is
without for again framing the guidelines with regard to this video conferencing.
Please, my lord.
With what it is made and what the rules that are
Please.
made. With that, you cannot, it's pure injustice to the other party. If you want, I'll adjourn the matter, you can take a chance.
Please,
But I'll not pass any order.
Please,
of
ma'am.
that nature. This matter on 18th of March.
lords, interim order, my lords, may be extended.
Any inter-modal grant is extended.
Please.
Bill
Yes.
number 44, Kalyanar for petitioner. We promote.
My lordship, kindly place 2 weeks time.
You have a stay?
Yes.
No stay.
No stay.
No increment.
There's this matter on 19th of March with the request of counsel for the petition.
Bill
Yes.
number 45, disposed 46. Bill number 46, H.N. Basavaraju.
The petitioner used different number 3 before the trial court.
No, nobody is contesting.
Notice.
Huh?
Dispense, R2 dispense, please, R1 served and.
R2 to R8 are dispensed with, R1 served, R9 served. Who are the contesting respondents?
Contesting respondent is only different number 9, my lord. The respondent number 9.
He served. What is the suit? What is IA?
Suit is, my lord, for partition.
IAS?
IA is, my lord, for impleading. Impleading the defendant number 9 as one of the party to the suit. Since, my lord, the
That application
and the defendant number 3 has filed the application.
to impede defendant number 9.
9. Let the property subject matter, my lord, 39.5 guntas was sold by the defendant number 1 and 2 in favor of defendant number 9 way back in the year of 1995. That was not, my lord, stated in the plaint while institute the suit. I'm not with, we thought,
You are the?
I'm one of the joint member of the family.
No, I'm saying you're the plaintiff. or
Defendant
the-
number 3, my lord.
You are the defendant number 3.
Three.
You filed this application.
I filed the application.
Application to impede defendant. number
Implead the
9.
defendant number 9.
So
Since he was a purchaser,
Which year is the
95, my lord.
95? Purchase, so sale was?
Sale. Sale was 1995.
Suit was?
Suit just in 2016.
Suit is of the year 2016.
16 for partition.
Hmm.
Lord, the first instance, my lord,
Hmm.
the trial court, my lord, allowed my application, my lord, directed to implead the defendant number 9 as a party to the proceedings. Later on, my lord, when the defendant number 9 has appears, he filed one more application, my lord, under order 1 rule 10(2) to strike off. I'm the unnecessary party since because the sale transaction has taken place in the year of 1995 and it is the cut-off date, my lord, from the amendment 2005, the Indula. Therefore, I'm not a necessary party to these proceedings. It is only to harass me, then this application has been filed. Trial court, my lord, allowed that application. Please.
Come to the order.
Order. Page number 43. Heard and perused on perusal of the application. I'm reason, my lord, last paragraph. On perusal of the application and affidavit filed by support of the application, make it very clear the applicant defendant number 9 is seeking to strike out or delete him from the suit. There was no cause of action from against any other reasons shown in Impleading as a 9th defendant to the suit. On perusal of the order dated 21/3/2018, passed IA number 7 and order 1 rule 10 by this court would show that 9th defendant has been added to the suit at the instance of the 3rd defendant, wherein it is stated that the defendant number 1 and 2 are told.
What is this order by the court?
My lord.
What is this order?
Then again, my lord, we filed one more application and
Let us see. No, this is impugned.
this is also one of the impugned. Another, my lord, later on, we filed on one more application under section 114, read with 151 to review the order,
This order.
this order. That's also dismissed. Both orders are under challenge now.
What is this reading? The record also reveal, in the affidavit attached to the application, the 9 defendants specifically contended that he is not at all related either to the scheduled properties involved in the suit or to the parties to the suit. The record also reveals that in spite of granting opportunities, neither the third defendant nor the plaintiff have filed any objections to the said application. Therefore,
Made out.
no,
I have filed the
to you,
sale deed along with them, please.
according to you, which is the suit scheduled property, which is purchased by him?
I have
Where is the plaint?
one more thing. I have filed a sale deed along with a memo.
Not memo
That's-
here, before
that's-
the court.
I will.
Before the court, in your pleadings,
Yes,
something
yes.
should be there. Where is that order impleading him as
As a defend number 9.
Number 9.
Please, my lord, I will. Page number 32.
No, this, in a review petition, court has gone beyond that original order and gave some more other reasons.
That is the reason. The 32 is the earlier, my application was allowed. Point number 1, may kindly page number 33. On consideration of the application and objection of the defendant, it is not in dispute that the proposed party is the alienee of the suit land bearing survey number 123/2 measuring 39.5 guntas. It was sold by the defendant number 1 and 2. It is only the contention of the plaintiff that as the alienee or purchaser had purchased the property prior to the cutoff date prescribed in Central Amendment Act
Why
came
did
into
you say that the other defendants were not necessary parties to this?
Lord, since I only made application, my lord, to implead the defendant number 9, they have not contested and they have not chosen to file any application or objections to the application. Thereafter, review also filed by me only. Section
Please
1.
come. Agreed with orders passed in I number 7, dated. Which is the date?
21/2/2019
21/2/2019.
and 25/6/2019.
First order is, where are the page number?
Page number, I will, please. First order, my lord, page number 43, dated 27/2/2019.
Agreed with orders.
Date is at 45, my lord, page number 45.
Order in an IA and order 1, rule 10(2), read with section 151 CPC. Dated 21/2/2019. And
And 25/6/2019.
and order dated 25th June 2019. This writ petition is filed. The petitioner before this court is the third defendant in the suit. The plaintiff has filed the suit for partition. It is the case of the defendant number 3 has filed an application on order 1, rule 10 to implead the defendant number 9 as party listed defendant to the suit. It is a case that the joint family property is alienated in favor of defendant number 9, and that came to be allowed by order dated.
By order dated 21, one minute, just, sorry, my lord. 21/3/2018.
21/3/2018. Thereafter, the defendant number 9 had filed an application to strike out or delete him from the suit. So the court had allowed that application, stating that it's a case of the defendant that he is not at all related either to the scheduled properties involved in the suit or to the parties of the suit. The record also reveals that in spite of granting opportunities, neither the third defendant nor the plaintiff have filed any objections to the said application, and therefore the reasons as made out in the application has actually been undisputed, unchallenged, uncontroverted, and accordingly allowed the application. The defendant number 3 had filed an application seeking review of the said order. That also came to be dismissed, observing that there are no objections or filed by third defendant. The court has passed such an order, and there are no orders, there are no reasons to review the order. Next para. Learned counsel appearing for the petitioner, defendant number 3 submits that when they have clearly shown and filed the sale list to show that the suit schedule, one of the suit scheduled property is sold to, has been purchased by defendant number 9, and on his application, he has been impleaded as a party, as a defendant to the suit. When an application is filed by the defendant number 9 to delete him, for deleting him as a defendant from the suit, the court ought to have given reasons, and just taking the pleadings of the defendant number 9, court had allowed the application, and further, when the review is filed, without considering the grounds raised in support of the review petition, I dismissed it. Next part. The notice to respondent number 2 to 8 is dispensed at the risk of appellant. R1 and R9 are served. No wakalat is filed on their behalf. Then this court has perused having heard the counsel for the petitioner, perused the orders impugned before the court. When there is a basis for the court to implead the defendant number 9 on an application filed by defendant number 3, order was not questioned, but it is unconnected with the plaintiffs. On what basis is saying that is unconnected? Court has not even considered that. Another important factor is defendant has not filed his objection. That there is no doubt there are lapses on the part of the defendant, but while striking out or deleting him from the suit as 9 defendant, just because the defendant number 3 has not filed his objections, that too, after allowing an application to implead defendant number 9, the court could not have passed an order in such manner. And also, the court has failed to review the order and the reasons stated by the defendant number 3. Considering all this, the order impugned liable to be set aside, and the matter requires to be remanded to the court. Accordingly, this court is passing the following order. Both the orders, the order dated so and so is set aside, and the matter is remanded back to the court. The third defendant shall file his objections, and on such objections, the court shall consider the case.
I have to file the objections to the application filed under 1 Rule 10 by the defendant number 9. Much obliged.
Is that, huh? Oh. No, pause. Yes.
Serial number 47. Thomas Vallipalli.
Your Lordship, we have retired from this matter.
Then-
We'll be filing a memo of retirement at the registry. A few years back only, we have given back the case file to the petitioner.
Interim order is there,
I think, Your Lordship.
but
I'm
will
not
not
sure.
extend it. Then counsel the petition submits that. They've already given up wakalat and they'll file a retirement memo. This is matter on 19th of March.
Much obliged.
Serial number
Okay.
48. K.N. Puttegowda, H.V. Harish for respondents.
Respondent vouchers. Interim order is there. no?
Interim order is there.
And
This
there's
is a case where, my lord, the plaintiff was a Hindi speaking person, lordships. He doesn't know the local language or English.
Hmm.
And my lord, at the time of cross examination, my lord, they requested that, my lord, a translator can be appointed. Lord, the court said, yes, any translator can be appointed. And we named the Bangalore advocates being a certain religion. And the court said, nothing like that, anybody can be named. My lord, those two orders, my lord, and the contention of the defendant is that, my lord, an expert has to be appointed for the translation of a cross-examination, having Ratna Award in the Hindi or something like that. That is income. For that, my lord, many years unnecessarily, my lord, there.
No representation for the petitioner, counsel for the respondent is present. Don't extend the interim order. List this matter on 4th of February.
Serial number
Even
40.
then, my lord, the mere pendency of the petition before this honorable court, my lord, the trial court, my lord.
Then we'll have it on
That tomorrow, I mean, Monday, my lord, can it be taken?
it's not possible.
Tuesday, Wednesday,
Wednesday.
please, lord.
29-1.
29-1.
Serial number 49. Ravi Shankar Shastri Ji for petitioner Sachin B.S. for
Petitioner,
respondents.
My lord, the plaintiff's writ petition, my lord, as against reject,
It's, your writ petition is going to be dismissed.
my lord,
He appears to be too happy.
my lord, we are happy that matter will be disposed of, my lord.
Yes,
My lord, the plaintiff's writ petition, my lord,
yes.
the suit is on for a specific performance of an oral agreement, my lord.
Hmm.
My lord, PW1 has tendered his evidence and marked certain documents, that is exhibit P1 to P21, my lord. Then, my lord, he has realized that two documents produced along with IA number 8 for production of the document, namely one GPA, my lord, executed by the defendant, which is the original one signed by the parties. And the second one is, my lord, an agreement, my lord, to be registered. These two documents were not marked in evidence. Therefore, IA number 9 was filed for reopening of PW1's evidence. My lord, PW1's tendered evidence marked the document, not cross-examined it. At that moment, this application IA number 9 came to be filed, my lord, for reopening PW1 for tendering those two documents. And my lord, IA number 10 was, my lord, filed to, my lord, produce that documents in evidence, my lord.
Come to the order.
By the impugned order, my lord, that application came to be rejected by the court below, both the applications, my lord. On the ground that, my lord, the documents are inadmissible in evidence, therefore it cannot be, my lord, permitted.
Yes. Come to the reasoning part.
Please, ma'am.
Page 18.
My lord, first order at page 13, my lord, running page
There are
30.
two orders.
Two orders, my lord, on IA number 9 and 10. Page 13, my lord, may I take? The plaintiff
It's
filed
about the
this.
reopening the case.
Yes, ma'am. Similar reasonings, my lord, for both the orders. May I read these reasonings, my lord?
Yes, yes.
The plaintiff filed this suit against the defendant for relief of specific performance of the contract. And now the above matter is posted for cross-examination of PW1. And this application is filed by the plaintiff by praying to reopen the case for the purpose of leading further evidence of PW1 to mark the documents which are produced along with IA number 8 and document number 7 and 8 mentioned in the list, and contended that the said documents are not marked in evidence by oversight. On the other hand, objection raised by the defendant is that said documents are not marked in evidence because the objection raised by the defendant's counsel. The document number 7 and 8 are unstamped and unregistered general power of attorney and agreement of sale dated 5/10/2015. It is well settled that documents which are unregistered, unstamped cannot be received in evidence. Thus, in support on the contention of the plaintiff, the counsel for the plaintiff produced the and relied on the decision reported in AR 2001 SC 1158,
wherein the Honorable Supreme Court held that subject to the objection document be marked and such documents objection to be decided at the last stage in the final judgment, and also relied on decision reported in ILR 2002 Karnataka 3613, wherein the Honorable High Court held that there is no total prohibition for receiving unregistered document in evidence. Unregistered partition deed could be received in evidence to prove any collateral transaction, and also relied on decision reported in 2015. Yes, my lord, this is a case where, my lord, the suit is one for specific performance of an agreement, oral agreement, my lord, which was later, my lord, by virtue of the, my lord, understanding between the parties were sought to be reduced into writing. And when it is sought to be registered, my lord, then the defendant turns back. My lord, they are relatives, my lord. Then, my lord, the present suit came to be filed. The exceptions carved under Section 49 Proviso of Registration Act is that, my lord, in a suit for specific performance, my lord, the unregistered document agreement, even it could be, my lord, marked in evidence and it is admissible, my lord. That is where, my lord, the courts, my lord, has failed to look into and appreciate, my lord. Please.
Please come back to the order at page 13. The document number 7 are unstamped and unregistered. No,
The-
the main agreement of sale is already marked.
No, my lord.
This is not the agreement of sale.
My lord, this document he wanted to mark, my lord, in evidence.
There is a question of saying that out of oversight, I have not marked the document.
My lord,
The basic document.
my lord, serially, my lord, the documents were produced along with the list of documents, my lord. My lord, it's were.
I can understand it is some other document you're seeking for a specific performance.
Yes.
And that is a document. How can there be any oversight?
My lord, what is stated in the application is that, my lord,
When
they
is
are-
the suit filed?
my lord, the suit was filed, my lord.
17.
In the year 2017.
Yes, please, my lord.
Ah.
My lord, list of documents were filed, my lord, on 18/1/2019.
Hmm.
My lord, then, my lord, evidence PW1 has tendered evidence.
What are marked by you on that day?
My lord, exhibit P1 to P12 on 1/2/2019 and exhibit P13 to 21 on 25/6/2019. My lord,
No, generally, in a suit for specific performance,
yes,
agreement of sale would be exhibit P1.
that's a primary,
generally.
my lord, it is it was produced at, my lord, document number 8 and 9. My lord, it was, my lord, totally misplaced by the.
What is exhibit P1 according to you?
My lord,
What is marked?
in the evidence, my lord.
There, my lords, relying upon an oral agreement that was entered into. And based on that, they have the contention is
Revenue.
that they have
Oh,
entered in.
they are not seeking.
No,
enforcement
not
of
based
this
on this.
agreement of sale.
No. Their contention is that whatever the oral agreement that was taken between the parties, that was later on entered into the agreement of sale by way of the.
No, let's look at the plain.
Please. Annexure B, my lord, page 21. My lord, the question would be, my lord, though, my lord, it is an unregistered document in a suit for specific performance, my lord, whether it could be marked in evidence or not.
No. Before that, let's see.
Yes.
What is that? For directing the defendants physically to execute a registered sale deed in favor of the plaintiff with respect to by way of a specific of the contract, oral agreement of sale.
39/2015 with the time fixed by the sound court, and on failure to do so, get the sale deed executed through the process of the court.
Oral agreement of sale means there is no agreement.
My lord, the agreement, my lord, there was an oral agreement, my lord, by virtue of the oral, my lord, the facts are like this, my lord. My lord, the plaintiff and defendant.
No, one fact
Yes.
you clarified.
Yes, ma'am.
There is a document or it's a oral, there should.
My lord, originally it was an oral agreement. my lord.
Seeking enforcement of what?
Original, my lord, oral agreement.
Huh.
My lord, to prove that there was an oral agreement, collateral purposes, my lord, later, my lord, by virtue of the negotiation, an
No.
agreement sought to be entered into. A draft agreement and a draft GPA. This is original signed by the parties, but it was not registered, my lord. For registration date was fixed on that day, my lord, defendant does not turn up. Then, my lord, the present suit came
No,
to
it is
fight.
like this. There is this improved order, but the 13th page
Please, my lord.
is referring to 5/10/2015.
Please, my lord.
In in a specific performance suit, that exception you're carving out,
Yes.
I can understand. if you're seeking execution of an agreement of sale dated so and so.
Please.
That is not what you're seeking. That is not, you're not.
That is
seeking-
not the prayer.
Then in that case, that exception, what is there, how will it come to your rescue?
My lord, I may respectfully submit, my lord, to prove that, my lord, there was an oral agreement, production of these documents are necessary, my lord.
No, that is a different
My lord,
aspect.
now the trial court holds,
No, no, your section 49 specifically
Yes.
fact, that how it will come to your,
my
that
lord,
would be, in case I can understand, if it is an agreement of sale, which you're seeking execution, that's a specific performance. If you're seeking, then we can at least try to understand what is the side of it.
Yes.
But not for this document.
my lord, I may respectfully submit, my lord, so far as the production of this document is concerned, my lord, trial court reasons, it is inadmissible, therefore I reject the prayer. That is where I brought it to my lord's kind notice.
No, when the
Such a reason,
documents are marked, when the documents are being marked, when it is not admissible in evidence,
my lord,
when it's unregistered,
Lord,
unstamped document.
my lord, when if it is sought to be tendered in evidence, then my lord, they can object. It is premature on the part of the trial court to hold that, my lord, this document is inadmissible. It is only for reopening and production of certain document I have sought for reopening, my lord.
No,
My
it's
lord, this,
marking of the document.
this honorable court has taken view that, my lord,
The marking of the document.
my lord, reopening PW1's evidence.
Open is one application.
Yes.
Otherwise, why you
For-
want to reopen it
I have,
to mark it?
I have stated that, my lord, it was for marking of these two documents I have misplaced.
So it is like either one is dismissed, other has to dismiss, has to be
Yes,
dismissed.
madam.
Purpose, just like that, why
Madam.
the court should reopen it to mark it, whether it can be marked or not.
My lord, the finding that it is inadmissible evidence is erroneous, my lord.
Then that we will say that
My lord,
not on that ground. Then on which ground your application needs
my
to
lord,
be dismissed?
to tender evidence to mark these documents, my lord. My lord, ultimately, my lord, these documents speaks about the purpose, my lord, how the transaction is.
Be marked.
My lord, it's the original one, my lord. Parties have signed it. It's a primary evidence. My lord, Exhibit P, document number 8 is a primary evidence, my lord, contains the signature of the parties.
In respect of an immovable property and agreement,
Yes.
and which is not a suit agreement of sale.
There are
at
two
all.
documents, my lord.
Both are nothing to.
My lord, one is GPA executed by the
It is
defendant.
also GPA.
Yes.
That also there is a unregistered, unstamped.
My lord, merely because it's unregistered and unstamped document, my lord, when a primary document is sought to be placed before the court, my lord, the rejection of the application is erroneous, my lord. On the ground that it is inadmissible in evidence. It's a primary evidence, my lord, original, which contains the signature of the parties.
So in this, if that's the argument to be accepted, in any of the cases, any document what the party is relying on, saying that this is so-called a document executed between the parties for any kind of transaction, just like that, the court has to mark the documents.
My lord, here is a case where, my lord, the suit is one for specific performance. It is not, my lord.
Going back to that,
My lord, the
specific
court, then,
performances.
my lord, courts have taken a view that, my lord, while tendering the, my lord, considering the application, my lord, giving such an finding is erroneous, and the duty of the court is to, my lord, such objection is to be permitted to be taken when it is sought to be tendered in evidence, not on the earlier stages of premature stage, my lord.
It's already this document, which you feel that it is a crucial document, you have not marked the document.
My lord,
After proceeding with the matter, now you want it to be reopened.
my lord,
reopened
the applications are two in nature, my lord. The IA number 9 was filed at the earlier stage,
interconnected.
earlier stage for reopening my evidence. Court rejects that. Then, my lord, I have no option. Then the IA number 10 was filed, my lord, to production of this document. My lord, on two different dates, my lord, two different orders. Ultimately, my lord, plaintiff wanted to cut short the, my lord, procedure and to proceed with the suit.
Please come. Agreed with the order. I agree with the orders passed in number 9. And 9 dated. What is the date of the order?
Please. That is
19/7.
2019.
2019. And
IA number 10,
IA
7,
number-
8, 2019.
IA number 10, dated 17/8/2019.
7, 8, 2019.
7 or 17 it appears.
17/8.
17/8/2019.
Please, 17/18.
17/8/2019, the plaintiff is before this court. The plaintiff had filed the suit seeking specific performance of an oral agreement of sale dated 30/9/2015 within a time fixed by the court. In the suit, he has filed an IA, that is I number 9, seeking to reopen the case for the purpose of leading further evidence. And I number 8. No,
10.
this is
I number 8 for production of document, my lord. 9 for reopening and 10 for production of these two documents in evidence.
And yes, reopen the case for the purpose of leading further evidence. And also to mark the documents which are produced along with IA 8 and the document number 7 and 8 mentioned in the list. And it is stated that the said documents are not marked in evidence by oversight. The document number 7 and 8 are the unstamped, unregistered general power of attorney and agreement of sale dated 5/10/2015. The court, by order impugned, had dismissed both the applications and observed that the suit is filed for the relief of specific performance of contract and the decision relied on with learned counsel or relating to some other facts and circumstances and not relating the suit for specific performance. And further, the court had negatived the contentions raised on behalf of the plaintiff, stating that though an unregistered, unstamped document can be marked, and this is not the stage where the court can take an exception to that. Mere marking of a document cannot amount to proof of such document. And when at an appropriate stage, while considering those applications, the court can record the objection and thereafter permit the document to be marked. The learned counsel appearing for the petitioner submits that is a document which the documents which he wants to mark are the GPA and the agreement of sale, where both the parties are signed. And he submits that there is an exception to, as per, that is section 49 of the
Proviso to section Proviso to section 49, Lordship.
Proviso to section 49 of the Registration Act. There is an exception for the document, for the agreement of sale from registration, and still the same can be tendered in evidence. He submits that as this is an agreement of sale, and that too in a suit for specific performance, the court ought to have allowed the application and permitted the petitioner to mark the documents and by reopening the suit for the further evidence. The court at the initial stage itself has given a finding and has decided about the admissibility of the documents, which is not permissible under law. He submits that at any rate, the court ought to have allowed the applications filed by the plaintiff. Then counsel appearing for the respondent, defendant submits that they are not seeking specific performance of an agreement of sale, that is exhibit A8.
Document number 8.
Document number 8, but they are relying on a oral agreement of sale. It is submitted that the exception which the learned counsel for the petitioner is arguing under section 49 of the Registration Act do not apply to this document. And the court had rightly considered all these aspects and rightly dismissed the petition. Dismissed both the petition. Next para, having heard the counsels on either side, peruse the material non record. This is a suit of specific performance based on a oral agreement dated 39/2015. After the marking of the documents, the applications are filed to reopen, and thereafter another application to mark document A8, what is that? Document number?
7 and 8, my lord.
7 and 8, which is a
GPA and
unregistered, unstamped GPA.
and agreement.
Draft,
Huh?
they are
Draft.
draft the GPA and draft.
Draft GPA.
And
a
draft agreement.
Draft
Agreement.
agreement of sale. The contention of the land consultation 49 is specific of the Registration Act. None of those submissions can withstand the legal scrutiny. For the document exhibit the document A7 and A8 or A9,
My lord, document number 7 and 8, my
a
lord.
document number 7 and 8. The section 49 of the Registration Act will not apply. And the suit agreement is a oral agreement. The oral agreement, the contention that as those are signed by the parties, and they're crucial for the case of the plaintiff. As such, they have to be marked, is also also cannot be appreciated by this court. The court had rightly considered that both the documents are unregistered, unstamped, draft agreement of sale, and rightly dismissed the petition. This court has no reason to interfere accordingly. Yes.
Till
Please.
50, Harish HV for petitioner, C.R. Abdul Rashid.
On behalf of the respondent, okay, for the petitioner in this case.
Yes.
Petitioner is a defendant, lordships. Suit is one for partition. My lord, the defendant's evidence, my lord, he has produced,
The partition, you are the defendant.
I am for the defendant.
Ah.
My lord, I have produced around 50 or 53 documents. My lord, 49 documents are marked in my evidence. My lord, my evidence is concluded and it is posted, the case is posted for cross-examination. At that time, my lord, I noticed that a document which is already produced before the court, and in the written statement, I have taken such a contention. My lord, is not marked. Then, my lord, immediately, though it is not for still cross-examination of the defendant, my lord, I sought to reopen the
What is
case.
that you want to mark?
Document is a unregistered partition deed, Palupatti, a family settlement,
Hmm.
based on which, my lord, the parties had entered into partition, and revenue entries are already mutated in the name as per the pursuit.
Rely on this for the purpose of
Severance of status and
severencing a part.
severance in the past, and also, my lord, for collateral purpose of that can be done, that could have been done. I have also in the.
What do you say?
Manoj, the present petition which they have filed for the marking of that specific document, there are 4 families, Manoj, actually. 4 families only. One of the part of the second family has done that particular partition in which their person missing. So in that scenario, the document ought not to be taken by the court rightly because the other persons are not, and it is moreover the
Whether the binding, what is the binding nature of that? It's always open to the court to decide it. Now, it is an unregistered
unregistered
document,
partition.
unregistered document. Now, the issue is about the what is the collateral purpose in this? That can be looked into for collateral purpose. What is a collateral purpose? So, Honorable Apex Court, relying on the judgment of the full bench of the Andhra Pradesh High Court, has taken a view. What is a collateral purpose in a partition suit? You have the judgment.
No, my lord, I have Karnataka court, Karnataka High Court
Supreme,
judgment.
so I'm referring to Supreme Court judgment.
Sorry, my lord.
What is that, the other day it is in, so there the Supreme Court has held, what is the collateral purpose in a partition suit? Look at the judgment.
Please, my lords, if I may be permitted to have some
Yes.
time, I
This
will
is matter
assist this honorable court
next
appropriately.
Thursday,
Please, my lords.
next Thursday,
29th, same on more.
29.
I will get that, I'll get
judgment
that
out.
additional.
Cell number 31,
Please.
P. N. Jayadeva for petitioner, Kashyap and Nayak.
51.
51.
Lord, I appear for the petitioner, my lord.
Yes.
For respondent in this matter.
Yes,
But in this case, my lord, there was a partition suit between the parties, between the siblings, matlab brother and sister, two sisters.
you have a intermodal in your favor?
There is a stay continuing, madam.
Interim
My
order.
lords, that from 2019 onwards, the FDP has been stayed.
When you.
And
when
it's
you-
been 30
when-
years since
when
I
you can,
initiated a partition suit.
when you
ma'am.
can come physically before the court.
Very well, my lord. Next
I'm asking-
Friday.
I'm asking Mr. Counsel for the petitioner. When you can be physically come before the court, appear before the court.
I'll be present, ma'am. I'll be present, my lord.
And then this matter also on Wednesday, 29th.
Much obliged.
Because finally little difficult it is.
I'll be present, my lord.
Much.
Which one?